Good morning, Your Honor.
It's easy for you to stay here. You know, I can bring it up and set it down for her.
What's the police code?
438.
Oh,
Phone number.
406.
406.
Oh, okay. We're going to trade.
Did she come yesterday? She did. Okay, because like 10 o'clock. I know that's about 2 blocks ago. Let's see what's good. Yeah, he told me he saw hers up. Hey, let's see. Morning, Your Honor. Good morning. How you doing? Fine, sir. Good morning, Arnie. It's very close. If it gets slipped with the free, might get both. No problem. I told you I want to play with it.
It's not when you go like 2 or 3 trucks.
I got the snow blower. I said, I told you I want to play with it. One of the years. Oh, yeah. Yeah. I used to want. Yeah, like. But,
Oh, yeah. So
That's what I need to get out. Too sure.
different. That's something.
Well, I think she's coming up.
So this is a 2D. Yeah. Two.
This is Sinclair.
He's here.
Okay. Oh.
First of all, he's like the very.
Miss Griffin.
property.
Ms. Ripley, that flash drive you brought me.
Yeah.
Everything worked, but the most important part, the interview of the defendants, there's no sound.
No
But
sound?
I do have sound for the other videos, but not for the interviews.
Okay. Let me work today. I
Okay,
will-
thank you. When is our hearing again?
Thursday afternoon.
Thursday afternoon, okay. Try to get that to me as soon as possible.
Absolutely, Judge.
Thank you.
Yes.
All right, Ms. Coleman, are you ready?
Good morning, Your Honor.
Good morning. What can I do for you today?
On Marion Scruggs, we'll be asking for a competency.
Okay, let me call it.
And I'm sorry, Judge, if I may, Larry King is on that one and he's running a little bit late.
Let me give him a call and let him know that we're asking for a competency.
Okay.
I thought I had his cell, but I just have the email in office. Can you text him?
I did just text him. Yes.
Oh, thank you. And
Yes,
good morning.
thank you. Good morning.
Good morning, Mr. Morgan.
Good morning, Your Honor. How are you?
Good, and yourself?
Fine, excellent.
What can I do for you today?
I'm here on Joshua Murphy. I just got retained on Saturday and I have not received a discovery yet. I'm 85% certain I'm going to weigh, but I think I need to at least read the discovery before I do that.
All right, so what we'll do is we'll try to get you the discovery today. This drain is pretty good in doing that. And we can set it for an exam approximately a week or so out.
Judge, but what I'm saying to you, I don't believe I'm going to have an exam. I'm almost certain I'm not, but I just need to read
That's
it.
fine.
Okay.
That's fine, but just in case things fall apart, I'm gonna already put it on track.
Okay.
And Judge, I believe that this is a CFAB case.
Oh, okay.
Hi, Judge. I'm here. Brittany Johnson.
Oh, okay, Ms. Johnson. She's also good at getting the discovery to you.
Okay.
We're ready on Murphy.
Calling case number 2306017101, people of the state of Michigan versus Joshua Murphy Senior. Defendant discharged of count one, child abuse first degree.
Appearances for the record, please.
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
Good morning, Your Honor. For the record, Richard H. Morgan Jr. appearing for Mr. Murphy.
All right. And Mr. Morgan, are you waiving your client's appearance?
Yes, Judge, but may I, yes, I'm waiving his appearance. I have another question I'd like to ask, though.
All right, the court will waive the defendant's presence. What's your pleasure?
I'd like to, as I indicated earlier, get the discovery. I don't believe I'm going to have an prelim, but without at least reading it, to make that call, it just doesn't seem to make much sense to be malpractice, not to at least take a look at it first. I would like for you to set it for another PCP, and I'll make that call then. But whatever the court's pleasure.
What's your P number, Mr.
P23924. I know that sounds ancient.
Brittany.
All right, I can set it for another probable cause conference this Friday, December 8th at 8:30.
That works.
That sounds perfect, Judge. And Mr. Morgan, I'll have that discovery to you before lunch today.
Oh, I appreciate that, great. Judge, I have one other issue. He got arraigned on the 28th of last week, and he was given a tether. And to date, he hasn't been out of the jail yet. I mean, does it generally take that long?
It does.
Okay. Could I get some idea so I can tell the family when they can expect him to be released? No.
I wouldn't know that. They would be in a better position to tell you that than me. The tethering unit.
So I should call the tethering unit, is what you're saying to me?
The tethering unit of the Wayne County Jail, yes, sir.
Okay, thank you, Judge.
All right, thank you. Have a good day.
You also.
Thank you. Have a good one.
All right. Ms. Coleman, Mr. King has arrived.
Thank you, Your Honor.
Ready to recall Scruggs.
Yes. Recalling case number 2306004501, because State of Michigan versus Marion Scruggs. Defendant is charged in count one, first degree arson, count two, assault with intent to murder, count three, home invasion, first degree, count four, arson, preparation to burn dwelling, resulting in injury. Count five, assault with intent to do great bodily harm less than murder by strangulation. Count six, malicious destruction of building, 20,000 or more. Count seven, assault with a dangerous weapon. Count eight, domestic violence. He has a domestic violence second offense notice.
Appearances for the record, please.
Good morning, APA Larry King for the people, P78774.
Good morning, Your Honor. Delisha Taylor Coleman, P56278, on behalf of Marion Scruggs. I do not see him in the Wayne County Jail. Would waive his appearance. When I went to speak with him this weekend, he was unable to assist me in his defense at that time. I am asking for a competency exam.
Court will waive the defendant's presence, continue to plead not guilty, and refer the defendant to the forensic center for a competency evaluation. We'll set a review date of March 12th, 2024 at 8:30.
Thank you, Your Honor.
Thank you. Larry, I have a couple things I'll get with you on.
Email's best, but we'll be in communication, okay?
Thank you.
Thank
Have
you
a
all.
safe, blessed day, everyone.
Thank you, you too. Ms. Pilkowitz, good morning.
Morning, Judge. I'm here on Reginald Ivy and Cordero Sherman. Is Mr. Ivy the gentleman in the box?
I'm sorry, what did you say about the box?
I was just asking if that's Mr. Ivy. I haven't had a chance to speak with him yet.
I don't know him personally. I wouldn't know. What's your name in the Wayne County Jail, sir? What is it?
Reginald Ivy.
That is Mr. Ivy.
Okay, Judge, if we could just do, I'm going to waive Mr. Sherman's presence. I have spoken with him, but if I could just get 2 minutes after we go on the record to speak to Mr. Ivy, I'll be good with that.
Sure. Okay, let's call Ivy.
Calling case number 2306-015701, people of the state of Michigan versus Reginald I. Defendant is charged in count 1, assault with intent to do great bodily harm less than murder. Count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Judge, Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Mr. Ivy. Mr. Ivy, state your name one more time for the judge.
Reginald Ivy. Reginald.
Your Honor, I am in receipt of both paper and digital discovery at this time. I'd like to set this one for an exam. Judge, I am in a homicide trial all of next week. Is it possible to set this for as late as like the 19th or 20th? I know Mr. Ivy's in custody. He has a personal bond with Tether. I anticipate he'll be getting out today.
I'm told that tethering is taking a long time to get to defendants. And that's going to be problematic. You can't do it next week. I can't do it until the first of the year.
Okay, yeah, I'm not gonna, okay. Can we do perhaps either Thursday or Friday in the afternoon? I know it's normally saved for your homicides.
Just Thursday, sir. I can do Friday afternoon, Friday at 1:30.
That would be great. Or
December
actually, you know what, Judge? We'll probably break for lunch. Can we do Friday at 12:30?
December 15th at 12:30, sure.
Great.
Okay,
And
December 15th at 12:30, bond will be continued.
thank you. Mr. Ivy, I have one phone number for you, 662-891-6515. Give me
That's correct.
All right, give me one more phone number, an emergency contact, just in case I can't reach you when you get out.
Okay, that's gonna be 313-492-8919.
I got them already.
All right, I anticipate you're gonna get out either today or tomorrow with the Tether delays because you got a personal on Friday, okay?
Okay.
And I will call you as soon as you're out.
Okay, so it's gonna be, you said a date?
And it's right now.
December 15th at 12:30.
15th.
Judge, I've got Cordero Sherman. I'll waive his presence.
Okay, I'm ready on Sherman.
Calling case number 2306-013601, people of the state of Michigan versus Sherman. Defendant is charged in count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence, aggravated second offense notice. Defendant also has a habitual offender second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Judge, Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Mr. Sherman. I'd ask that the court waive his presence. He's in the custody of the Wayne County Jail.
Court will waive the defendant's presence. What's your pleasure?
Your Honor, I am in receipt of discovery. I'd like to set this one for an exam. If we can back this one up to Mr. Ivy's, that would be great, either 12 o'clock or 1 o'clock. Or 12:15.
12:45.
That would be perfect, Judge. Thank you for accommodating my schedule.
All right, December 15th at 12:45, bond will be continued.
Thank you. Have a good day, everyone.
Thank you, you too. Mr. Cantor, good morning. Mr. Cantor? Unmute yourself, sir. There you go.
Good morning, Your Honor. Can you hear me?
Yes, sir.
Okay, thank you. I'm here for Gordon Bonapart.
Okay.
I have not had any contact with him, so I don't know if he's on Zoom or not.
Let me call the case.
Calling case number 2306-017301, people of the state of Michigan versus Gordon Bonapart. Defendant is charged in count 1, assault with intent to bring out harm less than murder by strangulation. Count 2, domestic violence. Count 3, malicious destruction of personal property less than $200. Defendant has a habitual offender, third offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Robert Cantor, P24993, appearing on behalf of Gordon Bonapart. Your Honor, I have not had any contact with Mr. Bonapart. I've called the number that was provided to me and there's been no response. So I don't know if he's on Zoom today or not.
No, he's not.
Your Honor, I have received the discovery. If I can get in touch with Mr. Bonapart, I believe he would want to hold an exam, but I don't know. So I'll leave it to the court.
Tell me what's your plan?
Well, I would try to get an investigator to find him. So I don't know if the court could adjourn the PCC.
Tell you what I'll do. I'm gonna set this matter for preliminary examination on December 15th at 9:30.
Okay. Very good, Your Honor.
I'm gonna locate him.
I will see what I can do.
All right.
Thank you very much.
Thank you. Let me see if I can. Let's see if I can get this one. We have a number for Mr. Cantor.
We have 734 421 26 10.
421 26. Good morning. Mr. Humphreys, what are you doing, sir? Mr. Humphreys.
Oh, good morning, Your Honor.
Good morning. What can I do for you?
I have a PCC.
Two.
Hold on one second. Last name spelled Robarge. Jessica first name.
I don't think you're in the right courtroom.
That's Ms. Drake, this is our case, because it's.
Still, you are called. Is that our case, Ms. Drain?
Marcus Buggs, is that right?
No,
Jessica Robar.
Jessica Robarge.
I don't have that. Was that added?
It was, I have the file, but it was set on Judge Giles' docket. It says DB.
It was set on Judge Giles' docket, but it says domestic violence.
Okay, I will let me look this up. I'm sorry, what was the name one more time?
Jessica Robarge.
Jessica Robarge, Robarge.
Okay, I'll look this up right now.
Ms. Barrett, good morning.
Good morning, Judge. They say I had this Lamonte Richardson, but then somebody contacted me and told me it was another attorney, and Miss Ripley had called me. So, Judge, I would just like to set it for a preliminary exam so we can get this straight, because I'm sure what's going on.
Okay, let me call the case. Ready on Richardson.
Calling case number 2306-007201. Section versus Lamont.
Right.
It is charged in count 1 criminal sexual conduct, 3rd degree. Count 2 criminal sexual conduct, 3rd degree. Count 3 controlled substance, delivery of marijuana to a minor. Count 4 assault or assault and battery.
Appearances for the record, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Good morning, Judge. Melita Barrett on behalf of Lamonte Richardson.
All right, what's your question, Ms. Barrett?
Judge, we're asking this matter be set for a preliminary exam, please.
The court will continue the plea of not guilty and set this matter for a preliminary exam. How is December 11th at 11:15?
Ooh, hold on one second, Judge. Let me look at this. Could you make it a little bit later?
December 11th at 12 o'clock?
Okay, that's good. Thank you.
That's good for you, Ms. Ripley?
Yes, Judge, December 11th at 12 o'clock works. And I know Ms. Barrett and I were talking, we weren't sure if she's the defense attorney or if it's going to be someone else. I know that the defendant, I believe, is out on tether and house arrest at this point. So I'm not sure if he talked to an attorney or knew to be here today. I'm not sure where his presence, if he knew.
Just filed an appearance, and Ms. Barrett is the only show in town at this time.
Okay.
Yeah.
All right, Judge, I'll be talking to you.
Okay, have a great day.
You.
12. December 11th.
And the Jessica Robarge case, yeah, it is a domestic violence case where the relationship is spouses, so it does belong here.
Okay.
Thank you.
Where did Mr. Humphries go? Okay. I guess he'll be back. Let me see. Mr. Humphries?
Good morning again, Your Honor.
Okay, are you ready now on Robar?
Yes, is she on Zoom?
No.
Okay.
Let me call it.
Calling case number 2306-013301 for the state of Michigan versus Jessica Robar. Defendants charged in count 1, weapons, dangerous weapons, use of self-defense spray bombs. Count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Jim P 38930 on behalf of the defendant.
What's your pleasure, counsel?
At this time, Your Honor, we'd ask that you waive her presence. I have been in contact with her, and we just got the switch this morning, and so at that point, so I'd ask you to waive her presence, and then we would ask for a preliminary exam date.
Court will waive the defendant's presence, continue to plead of not guilty, and set this matter for preliminary examination. How is December 11th at 10:15?
December 11th at 10:15.
Yes, sir.
That's a good time, Your Honor.
All right, December 11th at 10:15. Bond will be continued.
Thank you very much.
Thank you.
Thank you. Mr. Deagle. Good morning, Mr. Deagle.
Good morning.
You are here on
Bugs. Marcus Bugs.
Calling case number 23059950001. People State Michigan versus Marcus Bugs. Defendant is charged with count one, assault with intent to rape out of crime, that's criminal by strangulation. 2, weapons, felony firearm. Count 3, assault with intent to do great bodily harm that's been murdered by strangulation. Count 4, weapons, felony firearm. Count 5, weapons, firearm, discharge from a building. Count 6, weapons, felony firearm. Count 7, weapons carried to concealed. Count 8, weapons, firearm, possession by felon. Count 9, weapons, firearm. Defendant has a habitual offender third offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Ronald Debo, P 63897, on behalf of Marcus Buggs.
Sir, in the Wayne County Jail, what's your name? What's your name, sir? Mr. Mercy?
Yeah.
Hey, Mr. Murphy, your next court date has been adjourned to December 8th at 8:30. Your attorney, Mr. Morgan, is looking for you. You're all set, sir. No, he's not looking. Anyway, okay, Mr. Debo, are you waiving your client's appearance?
Yes.
For the waive the defendant's presence, what's your pleasure?
Maybe set this for a preliminary exam?
Yes, sir. The court will continue to plea of not guilty and set this matter for preliminary examination. How is December 11th at 11:15?
Do you have anything earlier?
I can do December 11th at 9:45.
That'll do. Thank you.
Okay. December 11th, 9:45, bond will be continued.
Thank you, Your Honor. Have a nice day.
Thank you.
Thank you. You too. Mr. Elsie, who is the attorney on McCray?
Your Honor, he's here.
Oh, he's here.
Good morning, Your Honor. The attorney's Lawrence Williams.
All right, he's here. We're ready on McCray. Good morning, sir.
Good morning, Judge.
Call me case number 2305-681-001, people of the state of Michigan versus Samuel McCray. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count 2, assault with intent to murder. Count 3, assault with intent to murder. Count 4, weapons, firearm, possession by felon. Count 5, 8, weapons, felony, firearm. Defendant has a habitual offender third offense notice.
Appearances for the record, please.
Good morning. Sorry, good morning, Your Honor. Ryan Elsie, appearing for the people, P81329.
Good morning, Your Honor. Lawrence Williams, Mr. Gray, P42912.
All right. So today's the day and time set for a competency hearing. Do we have a report back from the forensic center?
Yes, Your Honor.
I have also received a report.
All right. And do you stipulate to its findings?
I guess I did, Judge.
They find the defendant competent to stand trial. Is that right?
That's correct.
Okay. Mr. Elsie, you stipulate as well?
Yes, Your Honor.
The court makes a finding that the defendant is competent to stand trial. What's your pleasure, sir?
Your Honor, I know that I didn't know what Mr. McRae would be on video today. My intention today was to, in the interest of time, waive the exam. That's the next day of the proceeding. I talked to him about that. He's willing to do that. So, but if he's not on video, I guess we may come back to do.
Okay, why don't we try to come back tomorrow then? And I'll see that we get the defendant either in person or via Zoom in the Wayne County Jail. Because of course I can't wait it without him acknowledging it on the record.
Yes, that's right.
Are you available tomorrow?
Yes, absolutely.
Mr. Elsie?
Yes, Your Honor.
Okay, let's put it over to tomorrow at 8:30.
Okay.
Okay, thank you, sir.
Thank you, Your Honor.
Good morning.
Yes, this is Rob. Yeah, somebody just called from detention.
What's up, yo? Good morning, y'all. Can I roll all? Yeah, come on up.
What is it? Honestly, it wasn't too many hours. Yeah. Hey, what? What's the case?
Edward Edwards.
There you go. No, it ain't
No,
no.
that's the doctor for us.
What kind of case is it? Sure.
I think it's close.
Lucky. You really need to work on that. You need to work on that. Oh, Lord, it twisted up so quick. Look like you was on Maggie Beard. Is this on witness?
Yes.
This phone number is 467.
All right, just thanks. Excuse me, Don.
Yes.
Do you know about Taiwan Edwards coming down from Bree to do an examination?
Yes.
Okay, you have the document.
They're here.
Yes.
They're supposed to bring.
Did you bring the file? Oh, the clerk found it. Okay. All right.
Ms. Barrett, you're back?
Yeah, Judge. Did Mr. Nash come in?
Who's Mr. Nash? Who's Mr. Nash?
Oh, he was the one that we were trying to, it's off of Sabri's docket. Wanted to see if you would remove his tether, and they told us to Zoom over here to talk to you.
Oh, okay. Mr. Nash out here?
Let me see. I'm trying to see if I see him. Yeah, I don't see him. Gave him the Zoom number. I don't know what he's doing.
Is he Tino U61680? I have somebody in my waiting room named Tino.
That's probably him. That's him.
Okay. Okay, we got okay. Who was that? Okay. Okay. Okay, we can call that.
It's not on the document. It's call me, case number 2305-950701. Because the state of Michigan versus Leroy Nash. Defendant is charged in count 1, weapons, firearm, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons, dangerous weapon, carrying with unlawful intent. Count 4, weapons, felony firearms, second offense notice. Count 5, weapons, felony firearms, second offense notice. Count 6, weapons, felony firearms, second offense notice. Defendant also has a habitual offender, fourth offense notice.
Next, for the record, please. Laura, is that your case?
Yes,
Melissa.
Judge, sorry, I didn't know you were talking to me.
Appearances, please.
Laura Nersessi on behalf of the people, Your Honor. I am actually here for a matter that's actually on Judge Sabri's docket. It's the Monty Arnold matter that I submitted a motion for.
Well, this is off her docket too. We just wanted to address the tether, excuse me, Melita Baird on behalf of Leroy Nash. He wanted to request the tether be removed because he's starting a new job.
Starting a new job.
With Lawrence Cooper at Low Pro Movie.
So why do you have to take the tether off?
So I can go to work.
You can go to work with the tether on.
Working for a moving company, we have long hours. They had a curfew on my tether condition.
Judge, I actually don't know anything about this case. I've just contacted the courtroom prosecutors, letting them know that they need to zoom in.
I appreciate that. Thank you.
Thank you.
So what hours are you working, sir?
I work from like 8:30 in the morning up to 7:30 in the evening time, or sometimes at 8 o'clock, depending on weather conditions or where the job is.
Judge, it is set for a preliminary exam, so the court is aware. His preliminary exam date is December 18th.
And so what's your employer's phone number?
586-498-6755.
And the supervisor's name?
Lawrence Cooper.
And you work from what time again?
From 8:30 in the morning up to 7:30, or it could be up to 8 o'clock in the evening. Because when you moving people, you know, it's various locations that we have to go.
Give me a minute. What's your name again, sir?
My name is Leroy Nash.
Nobody's answering that number.
Is it the right? Did you hear me properly?
I sure did.
Well, that's my employer, sir. You know what I'm saying? If y'all could, you know, just keep check up with him, and I'm gonna give him a call and give him the court's number if I could do that as well. Is that possible?
No, you don't have to do that. What's your name, sir? What?
IYO.
Do I have a prosecutor from Sabri's courtroom here?
Judge, I'll handle it. They're not responding to me, so I'll handle it.
Looks like you just walked in.
He did.
Get your appearance on the record for Mr. Nash.
Good morning, Your Honor. Adam Bookbuck on behalf of the people.
So Mr. Nash is asking the court to adjust his tethering hours or remove it altogether. In fact, I think he's asking the court to remove it altogether. He said his working hours are from 8:30 a.m. to 7:30 p.m. or it could be to 8 p.m. depending on the date and circumstances. What's your position?
The people's position is to object to a full removal of the tether, Your Honor, given the intent of the charge here is very serious. Possession of a gun with unlawful intent along with the felon possession of firearms. Just when the officers did find Mr. Nash, he did come out and give like this one, that action. Further, he's an habitual threat. So completely removing the tether, the people will object. Adjusting the hours for his work, I don't have an objection. I think it's reasonable. I would just ask that the court receive confirmation of his hours and his actual employment.
That's what I'm working on now. I'm calling his employer, but no one's answering. So I've called twice, Mr. Nash. No one's answered. I don't have an issue with adjusting your hours if they're verified. Okay. Before I do so.
Okay, sir. I'll try to reach him, and if I can, I'll try to have him call the courts.
Well, you don't have to call me. Just tell him to answer the phone.
Okay, thank you.
All right, thank you. What else do I have on Sabri's document? Edwards, Mr. Edwards. Okay. We never got the file for that.
Your Honor, are we finished?
Yes, sir. Your bond is going to be continued until I'm able to verify your employment, sir.
Okay. So I still had a couple days on the 7 days because nobody's really communicated with me. I haven't received any paperwork saying anything as far as the tether thing. I just brought it back up because I had the court date today, so I was trying to get it removed due to me getting recent employment.
I'm not sure what you're asking.
I was given 7 days to go and get the tether.
Well, Judge, I guess we can readdress this on the 18th with Judge Sabri.
Okay.
Ms. Barrett.
Yes.
Is it possible I can speak to you?
Well, but the judge can't get your employer.
I know. No, I'm talking about just, as far as the whole case.
Yes, you can. You call me on the phone. You got my number. Just call me. That's what you've been doing. Just call me like you've been doing, and we'll talk. Okay, Judge. Thank you. Call me, Mr. Nash. You got my number. All right. Thank you.
Thank you. What case are you here on, Laura? Laura, what case are you? You have to unmute yourself. What case are you here on?
Sorry, I was talking away. I'm on Monty Arnold. I'm just concerned that maybe Mr. Washington didn't get the emails about the motion hearing.
What's the motion for?
It's a motion to adjourn the preliminary exam. The victim in the matter was stabbed by the defendant and he's still in intensive care as a result. In fact, he's intubated.
When is the exam?
Thursday.
Okay. This motion to adjourn.
Yes, sir.
Have you talked to Mr. Washington?
I have not, so I was gonna try to call over to NDS and see if there was an issue, like maybe he didn't receive the email. That's my concern, is that he didn't see the emails. So if I can have a moment, I'll try to give him a call.
All right. So what are we doing now? Go ahead, whatever.
That's a whole. Calling case number 2305-994501 for the state of Michigan versus T1 Edwards. Defendant is charged with count 1, weapons, firearm possession by felon, count 2, weapons, ammunition possession by felon, count 3, weapons carrying concealed, count 4, police officer assaulted, resisting, obstructing, count 5, police officer assaulting, resisting, obstructing, count 6, weapons, felony, firearm, second offense notice, count 7, weapons, felony, firearm, second offense notice, count 8, weapons, felony, firearm, second offense notice, count 9, weapons, felony, firearm, second offense notice. Defendant has a habitual offender for offense notice.
Appearances for the record, please.
Good morning, Your Honor. Alexander Kirker on behalf of the people, P86282.
Well, Judge Daniel Arm, behalf of Stratton Works, P61807.
Tell me your name for the record, sir. There's a date and time set for preliminary examination. Are we ready to proceed?
We are, Your Honor. Yes, sir.
How many witnesses for the people?
One witness.
Are you ready to call your witness?
We do have one preliminary matter,
Go ahead.
Your Honor. At this time, the people would move to admit pursuant to MCL 766.11B1B, a certified copy of the defendant's previous felony charge of weapons carrying concealed, which I'm now showing to defense.
Any objection? Admitted.
And at this time, the people would call Officer Mitchell Briggs. MITCHEL. Briggs.
Okay. All right, how are you?
All right.
I want to thank you also for what you're doing for my brother.
Oh, my pleasure.
My man.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat in the witness box next to me. You may begin when you're ready.
Morning. Could you please restate your name for the record?
Mitchell Briggs.
And are you currently employed, and if so, in what capacity?
Yes, as a police officer in the city of Detroit.
And how long have you been employed as a police officer?
About 6 years.
Were you employed as a police officer on November 12, 2023?
Correct.
Did you in fact work on that date?
Correct.
Were you by yourself or with a partner?
With a partner.
And what is your partner's name?
Christopher Smith.
And on this date, were you in full or modified uniform?
I was a modified uniform, police markings.
Could you describe that uniform?
It'd be black pants, black long sleeve, a police vest with the words police written across the back, a police badge on the front.
And were you on foot patrol or in a scout car?
In a scout car.
Is it a fully marked or semi-marked scout car?
Semi-marked.
And could you describe that scout car?
Yes, it's a black scout car with off-color lettering on the sides and back saying Detroit Police.
And did your duties as a police officer on this day take you to an area at or near Plymouth Road and Hubble Street?
Correct.
Then the city of Detroit, county of Wayne?
Correct.
And what brought you to that area on that day?
We were doing patrol in the second precinct.
And did anything happen while you were on this patrol?
Yes.
What was that?
We observed a minivan that did not appear to have a license plate affixed to it, parked at a gas station on the aforementioned corner.
And is this a civil infraction?
Yes.
And what did you do upon observing this minivan?
So as we observed that it had no plate, we were slowly passing it. We observed the male seated to your left in the passenger seat of the minivan.
When you say the male seated to my left, is there somebody in the courtroom today that you came into contact with on that date?
Correct.
Could you please describe what that individual is seated in the article of clothing they're wearing?
He's seated to my right, to your left, wearing a black long sleeve, a red tie.
May the record reflect the identification of the defendants. So note. So you stated you observed the defendant in the passenger seat of this minivan?
Correct.
And how many other occupants were there in this vehicle?
So as we were passing the minivan, we observed one other occupant entering the driver's seat. He was exiting the gas station, entered the driver's seat as he passed.
And did this vehicle drive off from the parking lot?
So we made a right-hand turn out of the parking lot and began going east. The minivan was directly behind us and pulled out behind us.
And did you continue to monitor this minivan?
Yes.
Did you conduct a traffic stop in this vehicle?
We attempted to, but we didn't quite reach that point.
And why were you unable to conduct the traffic stop?
So as we exited the gas station parking lot with the minivan directly behind us, he hit an immediate right southbound onto a street that was adjacent to the gas station. I had to perform a U-turn to get behind the minivan. As I turned down this street, the minivan I observed was parked on the west side of the road and it pulled over to the right. Mr. Edwards was exiting the minivan and began walking away from it, at which point the minivan sped off at a high rate of speed.
And did you continue to pursue the minivan?
We did not.
Did you continue to pursue the defendants?
Yes, for specific reasons.
And what were those reasons?
So as I observed Mr. Edwards exit the minivan and began walking towards us, his head turned in our direction. I observed the distinct imprint of a hand in his hoodie pocket.
Could you describe that imprint that you saw?
Yeah, it was in the shape of an L. There was a distinct outline where the handle of the firearm would be and the barrel, as Mr. Edwards was walking towards us. He clutched his hand towards it in what would be called a weapon retention upon turning his head in our direction.
And in what area of the defendant did you observe this imprint?
The hoodie pocket.
How far were you from the defendant when you observed this?
So we were closing the gap and we got pretty close to him. So I first noticed it. We were down the street just a little bit, maybe like 30 feet. And then we were closing that gap, approaching him in the scout car.
And what did you do upon making this observation?
Before I could really do anything, Mr. Edwards, having turned his head towards us, took off at a sprint down the alley going west behind the gas station.
And did you pursue the defendants?
Yes.
Were you on foot or in the scout car?
In the scout car and then on foot.
So how long did you pursue the defendant in the scout car?
Maybe 15 seconds, 20 seconds. He ran down the alley. We managed to slightly pass him in the scout car, at which time I observed that he had his hand grasping the firearm in the hoodie pocket. He doubled back and started traveling back east and then made a right turn to go south down an alley.
Did you exit the scout car?
Correct.
And did you pursue the defendant on foot?
Yes.
And about how far were you from the defendant when you were pursuing him on foot?
10 feet and buried as we pursued him. So he rounded the corner southbound into the alley just a split second before my friend connected.
I just wanted to clarify, you're saying was your partner also pursuing the defendant?
Correct.
Was he also on foot?
Yes.
And were you giving commands to the defendant at this time?
Yes.
What were those commands?
I don't remember the exact phrasing, but it would have been things like stop running, drop it, things of that nature.
And who was giving these commands?
I can't recall, my partner also was.
And at any point were you able to catch up to the defendants?
Yes.
Well, actually, before that, did the defendant comply with those commands?
He did not.
Did he comply at any point?
He became non-combative after we began.
So you were able to detain them?
Yes.
And at what point were you able to detain them?
So as we turned down the alley and Mr. Edwards continued running down the alley, he stumbled, tripped. He began to stand up, having his hands like in his waistband area still, where I had already seen the handgun. My partner discharged his taser, and it took effect. And at that point, we were able to apprehend Mr. Edwards.
And was the defendant compliant when you were trying to detain him?
Yeah, at that point, he became less combative.
And what did you do after detaining defendants?
We notified dispatch, we requested EMS due to the tasing. We stood Mr. Edwards up. I specifically began walking him back towards our scout car northbound through the alley. Prior to walking him though, we did search him thoroughly, and the handgun that I had previously observed on him was no longer in his possession.
And did you walk him back down the same path that you had pursued him down?
Correct.
And did anything happen while you were escorting the defendant back to the scout car?
Yeah, once we reached the mouth of the alley, so it's two alleys that come together in like a capital T formation. Once we reached the entrance to the next alley, I felt Mr. Edwards pulling away to the left. As I looked over at him, his head was tilted downward, his eyes were facing towards the ground. And I saw his foot start going over away from his body as though to kick something. I had to tighten my grip and pull him to the right, where I observed his head to be facing and his foot to be heading towards a discarded firearm on the ground.
And could you describe this firearm?
It was a handgun.
And just to clarify, you said the defendant was trying to kick this firearm?
That's the way it played out, yes. His foot was going away from his body towards the firearm, as though to nudge, kick, or push it.
Okay, and when this happens, this was still on the path that you had pursued the defendant down?
Yes.
And did you alert your partner to the firearm?
Yes.
Was the firearm recovered?
Yes.
Was the firearm loaded?
Yes.
Was the weapon placed as evidence?
Yes.
Did you expect any further investigation?
There's no CPL in lien for Mr. Edwards.
All right, no further questions.
Cross-exam. Officer, you said an initial contact with, post initial contact with my client, you saw an L-shaped item which you thought was a gun?
I believe what I said is I saw the clear, distinct imprint of a handgun in his right pocket.
Okay, later on, when you tased him or your partner tased him, did you see any weapons on him?
No, once he was detained and secured, no longer fleeing, we could not locate a firearm on him.
And then you said later on, you saw him assume that he was kicking the firearm?
So I observed him tilt his head towards the firearm on the ground, pull away from me towards the firearm on the ground, and move his left leg as though to kick it.
The firearm was on the ground, not in it?
Yes, he had discarded it at that point.
Well, that's what you're.
Yes, that's what I'm saying.
Imagine you're not testifying to that.
No, I'm not testifying that he had a firearm on him, and then that firearm was no longer on him.
So you tased him, you captured him, and you kept the firearm with him?
I didn't tase him. I'm sorry, what?
Your partner tased him?
Correct.
And then you handcuffed him?
Correct.
And later on, he was getting rid of the firearm?
I don't understand what you're saying, I'm sorry.
Well, when you tased him, you handcuffed him, right?
Correct.
Did you check him for firearms?
Correct.
There were no firearms.
There's no firearms on him once he's been, placed in handcuffs.
And you're telling me later on, when you're walking with him, accompanying him, you saw him drop a firearm and take it?
No. I'm saying that the firearm had already been discarded. We were walking back past it, and that was when it was already on the ground. He moved his leg and pulled towards it, is what I'm saying. So the firearm was discarded prior to him being tased.
Did you see him discard a firearm?
No, I did not see him actually throw it.
When you arrested him, there was no firearm, correct?
Yeah, it was not on this person anymore.
Can you redirect? Just briefly, Your Honor. You stated you had observed the imprints of a firearm on this person?
Correct.
Made initial contact.
Correct, concealed by clothing.
And during the pursuits of the defendant, did you see a firearm or the imprints of a firearm?
Correct.
And in what area did you see this imprints of the firearm?
It was in his hoodie pocket, as he was running, and we were pulling the car slightly in front of him. He had his hand on the firearm in the hoodie pocket.
And when you were on foot, did you see the imprints of the firearm?
Once our scout car started to pass him, he turned around and ran back the other way. So the location of the firearm was facing away from me at that point.
No further questions. All right. Sir, you said that this item was placed, firearm was placed on evidence, is that right?
Correct.
What evidence tag number was it placed on?
I don't recall off the top of my head. It would typically be .1 on the report number, but I could, if I was able to review my report, that would help
refresh your recollection.
Yes.
Your Honor, yes. Do you recall the evidence tag number? What is that?
It's .1. So it'd be the report number .1.
What's the report number?
23. I apologize. I had to refresh the middle four numbers again. So it'd be 23-11-12-0302.1.
You said this weapon was loaded?
Correct.
How was it loaded?
There were rounds in the magazine. The magazine was seated within the firearm.
Do you recall how many rounds?
We did not count the exact number in case there was usually it's typically to preserve the evidence. We don't count the rounds.
Were there any in the chamber?
I don't recall if there was one loaded in the chamber, but it would be reflected in the report.
Recall what kind of ammunition it was?
As in like the caliber?
Yes.
Again, I believe it was a 9mm, but I actually.
All right, any questions based on my questions? I have no further questions. No questions. Thank you, sir. You can sit.
Thank you, Brian.
Any other witnesses? No other witnesses for the people. Any witnesses for the defendant? No, the people. This time the people would move to find over the defendants on count 1, weapons, firearms, possession by a felon. Count 2, weapons, ammunition, possession by a felon. Count 3, weapons carrying concealed. Count 4, police officer assaulting, resisting, obstructing. Count 5, police officer assaulting, resisting, obstructing. Count 6, weapons, felony, firearm. Count 7, weapons, felony, firearm. Count 8, weapons, felony, firearm. And count 9, weapons, felony, firearm. As we heard from the officer, there was initially, we observed the vehicle without a license plate.
which they observed the defendant in the front passenger seats. They exited the parking lot before they could conduct a traffic stop on that vehicle. They saw the defendant's exit the vehicle and the minivan take off. On the defendant, as the officer testified, he observed the imprints of the firearm in the front hoodie pockets of the defendant, which he testified was they were still in the scout car about 30 feet away, but closing the distance to the defendants. At that point, officers determined that they would pursue the defendants. They're seeing this imprint of the firearm. The defendants, before the officers approached in the scout car, took off running in the opposite direction. Officers were able to cut the defendant off with the scout car, during which time the officer testified to still seeing the imprints of that firearm and the defendant clutching that area of his hoodie. Officers then exited the scout car. Both officers pursued the defendants. He was receiving commands from Officer Riggs to stop. No points to the defendant stop running. The officers actually had to tase him in order to detain him. He was then searched, placed into handcuffs, while escorting him back to the scout car along the same path that officers had pursued him down. And began pulling away from Officer Grace and staring down at the ground. As officer testified, making some sort of kicking motion. Officer Briggs then looked at where the defendant was looking down at and the direction that he was kicking. He observed a firearm. This firearm was then covered, was loaded. These also said rounds of magazine and placed into evidence. So people believe that the first probable cause of the Johnson.
Judge, as far as the gun is concerned, officer, that's like the same imprint of the gun. Not sure exactly what that means. It's not saying gun, it's saying officer said that they were following closely my defendant, my client, the defendant, within 10 feet, 15 feet. Didn't see anything dropping of a gun. Later on, they chased him. They found no weapons on him. Later on, as they were coming back, they saw him kicking a gun. Well, they didn't see him possessing a gun. They saw him kicking a gun. I would think any charges related to the gun, we could do some damage or on that. There's some basis for that.
To the contrary, officers observed the defendant in what they believed to have an L-shaped object on his waistband, which they believed to be a handgun, and the defendant took off running. They gave chase. He tripped, stumbled, fell, got back up, and they felt the need to tase him because he was resisting. Upon arresting him and taking him back to the vehicle, following the same trail that they had pursued him on, they observed the defendant allegedly trying to kick the weapon away from this person. That's what they said. I think circumstantial evidence is that the L-shaped item that they saw, that was the shape of a gun in their experience, was no longer on this person when they arrested him. And then walking back, following that same trail that they pursued him on, he's kicking the gun, trying to conceal the same from the officer's view, that is the weapon that he had discarded. The rational trier of fact could find that is the weapon that he discarded, given that he didn't have that L-shape side any longer. That he possessed that weapon, knowing that he is a felon and his rights to retain a weapon had not been restored. The weapon was loaded, the ammunition was concealed on this person. He did resist and obstruct the officers by running after them giving lawful commands for him to stop. and the accompanying felony firearms. All that being said, the court is satisfied that people submit their verdict of probable cause as it relates to the charges contained in the complaint. Court finds those charges were committed in the city of Detroit. The court finds probable cause to be listed. And will be arraigned in Wayne County Third Circuit Court Criminal Division for proceedings random on the information date and time December 19th, 2023 at 9 o'clock. Thank you, sir. Thank you.
Mr. Roberts.
What's next?
Mr. Ryan's case is in dismissal, sir.
Okay, let's go first. Who do you have, Mr. Roberts?
I have Arnell Phillips.
Okay.
Case number 230591100 for the state of Michigan versus Barnell Phillips. Defendant is charged in count 1, weapons carrying concealed. Defendant has a physical third offense notice.
Parents, for the record, please. Good morning, Your Honor. I look for appearing on behalf of the people, 86266.
Good morning, Your Honor. Attorney Sohar Faraj appearing on behalf of Mr. Phillips, who appears in person to my left. Mr. Phillips, can you please state your name for the record?
Nell Phillips. Is the date and time set for preliminary examination? Are we ready to proceed?
No, Judge, the people are not ready to proceed. The officers, central witnesses, which we have dealt with.
Your Honor, just want to tell me after this court dismisses this case against Mr. Phillips for lack of completing the security.
So order, court will dismiss this matter without prejudice. I need to dismiss the order.
Filling that out right now, Judge.
Is that it for Sabrina?
No, if you have another one, just show stuff up. You can swing all the stuff.
Okay.
Judge, since you're on a break, I wanted to give you an update. I have not been able to get a hold of Mr. Washington. I got a better number for his cell and I've left him a text message. I'm wondering if we could just put this over to Wednesday to give me some time to get a hold of him.
That's fine.
Thank you, Judge. I appreciate it.
What's your client's, what's the defendant's name again?
It's Monte Arnold.
Arnold. Okay.
Thank you.
Davis, right? June Davis.
Yes.
Calling case number 2305748801 for state of Michigan versus Carlos Davis. Defendant is charged in count 1 stolen property, receiving and custodian of the vehicle, second offense notice. Count 2 motor vehicles, concealing or misrepresenting identity with intent to mislead. Defendant has a habitual offender or defense notice.
Appearances for the record, please. Good morning, Your Honor. I look for appearing on behalf of the people, 86266.
And good morning, Your Honor. Alexander Choate with the Neighborhood Defender Service, P85948, appearing on behalf of Mr. Davis, who's not currently present in court. I believe he is still currently in custody and is not brought up, Your Honor.
I guess the people would ask for a new date to be set, Your Honor, just so we can be ready to.
Well, we try to get him over here.
Your Honor, he had a probable cause conference, and the date was set, so I believe a writ was sent over to the jail system.
I mean, this morning, did anybody call over to the Wayne County Jail, find out what's going on, why it happened?
Yeah, he was picked up on a parole violation, so they took him back to NDOC.
Oh, it was an NDOC.
Yeah, I believe.
Oh, guys, that part out.
And that being said, Your Honor, I would request a dismissal because this does go past the short date period.
Cisco, he's not here. We're gonna need 2 weeks to get him ready back to NDOC. I have no idea what this exactly like. This will be December 21st with the measure. Is that good for you?
Yes, Your Honor, I have one hearing in the morning, if it's possible to do anything after 9:30, 10 o'clock.
How about 10 o'clock? It's December 21st at 10 o'clock.
So, whenever you're done, I guess you'll call. So, read. Yeah.
Just want to confirm.
Yes. Yes, yeah.
I got all that. Is that it for Sabri's document? Yeah. Judge, how are you? Good, sir. How are you? All right. Are we ready? Weaver and Peterson.
We're missing Mr. Sinclair.
He was here. I haven't seen him. He was here. He came in. Hey, how you doing?
Are you looking? No, I'm not. I'm just gonna add for. Okay, so. Yeah.
Yeah, we can come up when our witnesses are called, one of us can sit back there.
If not, you want to have a table position here.
Yeah, that's fine. And I'll let her sit here.
There he is. You're alive. Okay, how are you? Good, sir. How are you? That's all we need our defendants. Say again, please. That's all we need our defendants.
Thank you.
Oh, sure. Yes.
How are you?
Can I bring them right on out as they come, Your Honor?
Yes.
Okay. Good morning.
That's my standard. That's
How are you?
But I'm not.
I don't know if I've met you before. Excuse me. So nice to meet you. Pleasure.
You said you haven't.
I don't think. She's a shame, yes. I see.
So, Tiffany, the other defendants. Names are a bit of a challenge for me.
I know, I used to be so good. I remember all the jurors' names.
Yeah, confession, I was never there. I like jury.
Yeah, I know.
Some judges are like adamant, like, do not call them by their names.
I know.
Alright, wonderful.
Right, who's our timing?
Listen to why.
Your attorney, Sinclair or Simmons? Come on.
Sorry, make yourself a little sad.
It's like a meeting, yeah. Oh, 1 second. Lisa. Yeah, how do you spell your last name? D-W-Y-E-R. Do you have to appear? I do. Okay.
Okay, you can have the other defendant ready. The other defendant is here.
Sorry about that, thank you. Thank you, boy. Good morning, sir. Your name? All right. Come on. No, not bad.
Let's see here.
There you go. Hey.
Sit here.
No?
I can sit next to you.
Calling case 2359427. People of the State of Michigan versus defendant number 1, Sean Weaver. Defendant number 2, Tyrone Arbor. I'm sorry. That's AKA Tyrone Arbor. Deshaun Darnell Arbor. Lamar Christian Jones. Sean Lamar Weed. Sean Anthony Weed. Defendant number 2, Derek Lamar Peters. Both defendants are charged in count 1 homicide, murder, first degree, premeditated. Both defendants are charged in count 2 assault with intent to murder. Both defendants are charged in count 3 assault with intent to murder. Both defendants are charged in count 4 assault with intent to murder. Both defendants are charged in count 5 weapons, firearms, possession by a felon. Both defendants are charged in count 6, 7, 8, 9, and 10 felony firearm. Defendant 1 has an habitual offender 4 defense notice, mandatory 25-year sentence. Defendant 2 has a habitual offender 2nd offense notice. Appearances for the record, please.
Dominic DeGrazia, 69815 on behalf of the people. And good morning, Judge. I'm Christopher Sinclair, the 80512, appear with on behalf of Mr. Weaver, who's present standing behind me.
May it please the court, Judge. My name is Adam. Limits P number 77233, appearing on behalf of the defense. Sir, state your name, please. I have co-counsel.
Your Honor, Lisa Dwyer, appearing on behalf of Derek Peterson.
Sir, behind Mr. Sinclair, what's your name? Sean Weaver. All right, today's the date and time set for preliminary examination. Are we ready to proceed?
Yes, Judge.
How many witnesses?
I believe at least 5.
Before we go there, let me address the folk that are in the audience. there are a number of you here, and quite frankly, I don't care on what side of the coin you fall on. These proceedings can get somewhat emotional, but I want you guys to remain under control. In fact, I shouldn't know that you're in here at all. If there are any disturbances whatsoever, we're gonna have to remove you. And I prefer that you're able to walk out the door that you came in. If you become disruptive or whatever, I'm gonna do what I have to do. And again, I don't care what side of the coin you fall on, but I should not know that any of you are here, okay? If you are unable to control yourself or your emotions, I ask that you excuse yourself. Okay? Any preliminary matters before we begin?
Yes, sir. First, I would ask for an order of mutual sequestration with an exception to the officer in charge.
Any objections to the last year, man?
None, Judge.
No.
No.
Okay. Ladies and gentlemen in the audience, if you are a witness or potential witness, I'm ordering you to step out of the courtroom at this time. Also, for the people that are viewing in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time.
I'm also at this point seeking to admit People's proposed exhibit 1, which is a postmortem report from the Wayne County Medical Examiner's Office concerning an examination on the body of Alasia Jones. That's Alaysia, performed by Dr. Omar Reyes on November 24th of 2023.
Any objection?
For exam purposes, no.
Say here.
And the report indicates that it was Dr. Reyes' opinion that Ms. Jones' death was caused by a gunshot wound to the back, and that the manner of her death was homicide.
With that, Your Honor, before the call, Officer TJ Yessian. YESS High.
Good morning, sir. Please step forward. Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please have a seat with this box next to me. Keep the voice up nice and loud and speak to the microphone to your left. Baby, get me ready.
Good morning, sir. Could you please state your name and occupation?
TJ Essian, Detroit police officer,
And how long have you been a police officer for?
about a year and a half.
All right. And were you working as a police officer back on September 23rd of 2023?
Yes,
And did you have an occasion to go to the location of 17630 West 7 Mile Road in the city of Detroit?
yes,
And now, when you went there, did you go there with any other police officers?
yes.
Who did you go there with?
My partner, Officer Nasser,
And did you ride there in a scout car?
yes.
And why did you go to that location?
We had a police run for a shot spotter as well as a gunshot wound police run.
All right. And did you arrive there around 2:31 in the morning?
Yes.
So just describe what you observed when you first arrived there.
When I arrived, I observed a large crowd in front of the location. People screaming that someone was shot.
Objection to your statement. Sounds like it would be an excited utterance.
The foundation.
So you said that there were people screaming.
Yes,
Now, were they just screaming on their own, or did you have to talk to them before they started screaming?
they were already screaming when they saw us pull up.
And how did they appear to you, just in terms of their emotion when you observed them when they were screaming?
They were frantic. They were screaming for help.
Judge, I think this qualifies as an excited utterance.
I will allow.
You said they were screaming?
Yes,
What did they say?
they were screaming for help and asking for us to come help the people that were shot.
Now, can you estimate about how many people were standing around this location on 7 Mile Road?
I would say approximately 50 people.
And are there any businesses located at that location?
Yes,
What business?
I know of I believe it's a hookah lounge, a smoke bar.
Now, outside of the hookah lounge, do you recall whether there were any parked vehicles that would be unusual in and around that street outside the local lounge?
Yes,
What did you see?
there was a red food trailer, that was sitting on the curb outside of the location, on the north side of the street.
So, did you get out of the car with your partner?
Yes, I did.
So what did you do when you got out of your car?
We ran up to the crowd where they were screaming for help.
And did you make any observations about whether anyone appeared to be injured when you first arrived?
Yes,
What did you see?
there were two people lying on the ground. One was face down on the pavement, and the other, they were both females. The other was lying on top of her, crying.
Now, relative to the location of this food truck, where were these two individuals who appeared to be injured in some way relative to the food truck?
They were directly next to the food truck to the east of it.
And now you mentioned a lady who was, I think you said, was it face down on the ground?
Yes,
All right. When you first arrived, was that person moving at all?
no,
Okay. Did you have a chance to walk up to this person and make any observations about their body?
yes, I did.
And did you see any apparent injuries when you walked up?
I only saw blood. I was not able to see a particular injury.
All right. Where was the apparent blood on their body?
It was coming from, it looked like the mouth or somewhere from the head area. It was on the pavement.
Now, when you first approached, that person appeared to be alive when you first got there?
No,
You mentioned that there was another person next to this person who was apparently deceased. Is that true?
yes, lying on top of her.
Describe your observations about that person.
She was lying with her back towards us, so again, face down on top of the first victim that I mentioned. And she was crying. And at that time, I hadn't known that she was injured. And when I tried to pull her off, to render aid to the unresponsive victim on the floor, she had blood on her as well, and she revealed to my partner that she was shot.
I hear you better when you stand. Gotcha.
Now, when you talked to this person, was she describing her current physical state to you?
She primarily spoke to my partner. My partner relayed the information.
So you didn't actually hear her yourself?
Correct.
Okay. When you got a chance to look at her body, did she have any apparent injuries to her body that you could see?
Yes.
Where was that on her body?
She was bleeding from one of her knees and from her abdomen as well.
Did you ever learn the name of this person who was alive with apparent injuries to her?
Yes, after she went to the hospital.
What was her name?
Miss Cornisha Vaughn.
All right. Now, the person who appeared to be deceased on the ground, did you ever learn what that person's name was?
I believe it was relayed to me by an officer at the hospital, but I don't
That would
recall.
be, you say whatever related to her, plus identification.
Later on, you think you may have received a name?
I believe so.
Do you recall what the name was?
No, sir.
Looking at a document question.
Yes.
And this, in the narrative of your report, are these different alleged victims identified by numbers?
Yes.
Okay. So this deceased individual, what number was she associated with in your report?
Victim 1.
Sorry. Hey, approach it. Does that refresh your memory about what that individual's name was?
Yes, it does.
And what was her name?
Miss Elijah Jones.
Now, aside from these two females that you've described, did any other individuals ever approach you while you were at the scene who appeared to be injured in some way?
Yes.
Describe how that occurred.
While we were processing the scene and setting up the perimeter of the scene, we were approached by an additional mail that was dropped off. that's stated to me and to my partner that that he was also.
Well, I asked what the strike is, the rest of the statement.
I think it would qualify as an exception to the hearsay rules for a statement of non-existing physical state.
Yeah, foundation.
All right, so when you walked up to him, or when he walked up to you, I'm sorry, did he tell you about something that was going on in his body right at that moment?
Yes, he described pain that he was feeling at the time.
All right, and did he come up to you unprompted, or did you have to go and find him and start interrogating him?
No, he came to us.
All right, and when he did that, was he asking for some medical attention?
Yes.
From you?
Yes, he was asking for me to get him medical attention, yes.
Judge, I think this qualifies under the exception.
Let me see.
What did he tell you?
He stated to me that when he was at the location, he heard gunshots and left the location after hearing the gunshots. And that he returned because he was feeling heat in his back and pain in his back, stating that he believes he was also shot.
Did you notice any apparent injuries to his body?
Yes, when we pulled up his shirt, we could see a large red area on his back that was consistent from my experience with a graze wound, and there was also a hole in his shirt in the back.
Now, in terms of your, you mentioned that you secured the scene.
Yes, sir.
Did you notice any apparent firearms related evidence in and around that scene that you were at?
Yes, there was casings in the area.
Fired cartridge casings?
Yes, sir.
Describe roughly where they were relative to any landmarks in the area.
They were approximately 20 to 30 feet to the west of the red food trailer that I initially described.
Okay. And were you able to determine whether they were the same type of caliber, or did you actually ever pick them up or anything like that?
I was not able to pick them up, no, sir.
All right. So you just happened to see them on the ground?
Yes.
Okay. And when you saw them on the ground, did you do anything with them?
I continued to set up the scene to make sure that they weren't disturbed.
I don't have any other questions, Judge.
Cross-examine.
1 second, please. No questions for you.
Yes.
Good morning, officer.
Good morning.
Officer, you indicated that you responded to the scene on West 7 Mile, is that correct?
Yes.
You were accompanied with other officers?
Yes.
You were wearing a body cam on that particular day?
Yes.
Was it operational when you approached the individuals that were injured?
I believe so.
During the course of your investigation, you had an opportunity to speak to some other individuals as well, is that correct?
Yes.
You get any information about how many people were armed at the scene?
No.
Were you able to observe any firearms or ballistic evidence that was present at the scene?
I was able to observe the fired cartridges, the casings on the ground.
How many did you see?
I'm not sure the exact number, sir.
In relationship to the 2 young ladies that were injured, did you see any cartridges immediately around them?
No.
You fired bullets immediately around them?
Yes.
Did you enumerate that in the report, how many you saw, or is it just one?
I don't believe I ever got a particular number to be able to put it in a report.
It's not your job to collect and process evidence, is that correct?
Correct.
That would be for the evidence test, is that accurate?
I'm sorry, I didn't hear you.
That would be for the evidence test, is that accurate?
For scenes like this, that's correct.
The individual that was a male that approached you indicating that he believes that he may have suffered an injury, do you know whether or not he was armed?
No, I don't know.
Did you check him for weapons?
I did not personally check for weapons.
Did you see anything consistent with individuals that was concealing a firearm on his person when you observed?
No.
Thank you. Nothing further.
Can you recorrect?
No, Judge.
Thank you, sir. You may step down.
call Sergeant Reginald Beasley. A-S-L-E-Y. Reginald.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please have a seat in the witness box. Maybe give him the right.
Good morning, sir. Could you please state your name and occupation?
Reginald Beasley, Detroit Police Sergeant,
And where are you currently assigned?
Homicide Task Force.
And were you working in that capacity when you became, or did you become involved in the investigation into the death of Elijah Jones?
Yes, sir.
All right. Now, as part of your investigation, are you aware of whether or not any surveillance video was recovered from the location of 17630 7 Mile Road?
Yes, it was.
All right. And have you ever personally been to that location?
Yes.
Now, have you ever had an opportunity to look at the surveillance video?
Yes.
Did you recognize anything depicted on that surveillance video as being from the location of 17630 West 7 Mile Road?
Yes, sir.
And that's after you've personally been there?
Correct.
All right, and in the course of your investigation, did any of this video appear to be relevant to your investigation?
Yes, it did.
Your approach to it.
Ma'am?
Approaching what's been marked as People's Proposed Exhibit 7, do you recognize the series of those documents?
Yes, sir.
And what are those photographs of?
This is from a living security camera that was mounted by the front door location that faces the sidewalk directly outside. It shows group of individuals, including 2 defendants, and the victims.
Judge objection. No, he can't do that.
Sustained. That's evidence.
All right, so
Video speaks for itself.
let me ask you this. Do you recognize those still images as still images taken from the surveillance video?
Yes, sir.
All right, and the images that you have before you today appear to be fair and accurate representations of the video itself that you looked at.
Yes.
All right. People would move to admit People's Proposed Exhibit 7.
Any objection?
No.
Admit it?
Get a motion for the court.
Yes.
And at this point, I'm also going to move to admit People's Proposed Exhibit 2, which is the actual surveillance video that Officer Beasley just testified.
Any objection?
Which one, just for the record, so it's clear?
Which video?
Yes.
There are a series of videos on People's Exhibit 2. I will give you the file number, I guess, when I'm about to wait.
Any objection?
No, I more so meant what business, but that's fine. You know, we got a bunch of videos from businesses along the 7 Mile. Just want to make sure the record is clear as to what video was made for business.
It's video from 17630 7 Mile.
Excellent.
Admit it?
So I'm now going to display on the screen the video file that ends the last 4 digits 5428. Oh, officer, displayed on the screen in front of you, do you recognize that as video from 17630 7 Mile Road?
Yes, sir.
Now I'm gonna play the video.
You play that one more time, please.
Judge, I'll slow it down a bit. This is running at 50% speed.
I'm sorry, one more time, please.
Sure. Yeah. Thank you. All right, I'm also going to play part of People's Exhibit to the video file that ends in 5424.
Judge, will the court admit me into the zone, please? Thank you.
See.
In the waiting.
Okay. I'm not going to play this video. I'm going to play the video ending in 5425. I'm going to play the video ending in 5426. And one more time, I'm gonna play the video anyway. By Word Julie.
Can you do 5428 one more time, please?
Playing video. What's the 15 seconds? So Sergeant Beasley, after looking at that video, did you notice if any of the suspects were in particular items of clothing that were significant?
Yes.
Specifically, what items of clothing did you notice?
So one suspect had a baseball cap and a jacket. Another suspect noticed a beard, and I'm not sure exactly what he had on.
Were you ever able to identify any of the deceased individual when you observed the video?
Yes.
And where was that person standing when you looked at the video?
She was standing outside of the food trailer that was east of the camera. She was standing outside the truck. When the shots happened, you can see her go towards the back of the truck and she falls over onto the ground.
I don't have any questions.
Awesome, Sam.
Your Honor, on behalf of Mr. Peterson, well, we won't be having any questions.
Okay. No questions, Judge. All right, thank you, sir. You may step.
We'll next call Trooper John Thibodeau. T-I-A-U-E-O. John J-O. Right here.
So please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat and witness box next to me. And when you're ready.
Good morning, sir. Could you please state your name and occupation?
To me, Jonathan Toronto, Trooper Protection State Police.
Now, on October 13th, 2023, in the area of Dobry Drive in Sterling Heights, Michigan, did you interact with the person who was ultimately arrested?
Yes.
And what was that person's name?
Check.
All right, we're looking at the report, refresh your memory.
It was.
So we can do the microphone so
We pull it down. Mr. Derek Peterson, there was a passenger vehicle as well.
You see Mr. Peterson in court today?
I do.
You point to that person, describe who he's with.
He's in the green jumpsuit, white undershirt, mask on face.
For the record, the witnesses identified the defendant, Derek Peterson.
So noted.
How did you come about interacting with him?
It was a traffic stop.
And was that in the area of Stowlery Drive in Sterling Heights?
Yes, it was.
And were you working with any other police officers?
It was a joint task force, special investigation section.
And when you pulled over the vehicle, was the defendant inside the vehicle?
Yes, it was.
And was he driving the vehicle?
Yes, he was.
And so describe what happened when you approached the vehicle and interacted with it.
So it was more of a takedown than anything. It was detectives gave us a call. My specific job set is to take down or stop vehicles that would possibly have a higher risk of taking off or leaving the scene of a traffic stop. So it was more of a takedown of the vehicle. I pulled in front of the vehicle with emergency lights on, had a trooper pull behind the vehicle with emergency lights on. And we ordered the driver out of the driver's seat.
No, when you say the driver, you mean the defendant?
Yes.
And when he got out of the driver's seat, did you pat him down or search him for anything?
So I was at the front of the vehicle, so I would have been the first to have him come out of the vehicle. That would have been Trooper Kaiser. But it was stated that he had a gun.
Objection here,
He told Trooper Kaiser told me.
All right. Same objection.
You say he, do you mean Derek Peterson?
Yes.
And did you hear him say that? Did you hear him say those words himself?
No.
You're saying referring to any words, those words are Pearson.
Oh. They're stated by the defendant.
Not if they're related to a third party, Judge, that he didn't observe.
Fair enough. It's just asking questions.
Okay.
In any event, did you ever go over to Mr. Peterson and search Mr. Peterson?
Yes, I did.
And did you find anything when you searched him?
Yes, I did.
Describe what you found.
In his right sweatpant pocket, there was a pistol, Glock 26.
Is there a serial number associated with that pistol?
Yes, there is, and it should be indicated.
You don't remember it off the top of your head?
No.
When looking at your report?
Yes. In the report shows Glock 26 serial number AEXD593.
Now, aside from this firearm, did you see or find any cellular devices associated with Mr. Peterson?
There was a cellular device inside the driver portion of the vehicle. It was kind of like propped up on the seat, kind of by the center console.
Did you yourself collect and confiscate that cellular device as part of evidence?
No, I did not.
Do you know who did that?
It would have been a detective.
Or any other questions?
Cross exam?
Yes. Sir, good morning to you.
Good morning.
I'm gonna ask you some questions. If I speak too fast or ask you a question you don't understand, let me know. I'll try to ask you a better question, okay?
Yes, sir.
All right. Now, on this particular day, you indicated that you were executing what you described as a takedown. Is that correct?
Paper, yes.
Correct. Did you have a specific target or individual name that you were supposed to be taking down?
It was a specific vehicle.
Okay. So regardless of who was driving the vehicle, you were gonna execute a stop and detain that individual. Is that correct?
Yes.
Okay. This wasn't a set of circumstances where this individual had committed a traffic infraction that you observed, correct?
That's correct.
This wasn't a set of circumstances where the operator of this vehicle had committed any offense that would allow you to have reasonable suspicion that criminal activity was afoot, correct?
It would have been a probable cause stop.
Okay. Not probable cause that you developed, correct?
That's correct.
You relying on information from other people, is that accurate?
That's correct.
This is not information that you affirmed, correct?
That's correct.
Okay, and as far as you know, the individual that was taken into custody or placed under arrest, there was no warrant for his arrest at that particular time, correct?
I believe there was a misdemeanor warrant.
Out of what jurisdiction?
I don't know.
And when you talk about misdemeanor warrant, you knew that prior to stopping the vehicle?
I was told that there was warrants for the driver.
So you didn't have personal knowledge of that, correct?
It would have been looked up in the computer system.
Okay, so nonetheless, you didn't look it up though, right?
I can't account whether I did or did not.
And even as you sit here and you testify today, whether you looked it up or not, you don't know what it was for, correct?
I would have at the time, but you know.
Right, but you authored a report in this particular matter, did you not?
That's correct.
And in your report, you don't enumerate this, that this individual had an outstanding warrant for their arrest, do you?
Don't believe so, but I don't have a report.
Right, so what I'm saying to you is, as you testify before this court, you don't know what the misdemeanor warrant was for, correct?
Right now, no.
You don't know whether or not there was a bond on the misdemeanor warrant, correct?
I can't account for that now.
At the time that you executed the stop on this particular vehicle, you didn't even know that the person that was driving was the person that actually had the warrant, correct?
The driver's name was called out, I just didn't account for it in the report.
I appreciate that, but you're the one who executed, who operated your overhead lights to stop this vehicle, correct?
That's correct.
So the onus of about being able to determine whether you had probable cause to stop the vehicle would be on you, correct?
I don't know that to be correct.
Okay, thank you. Judge, I move to suppress at this time any evidence that derived from this traffic stop. No further questions.
See, I don't have any other questions. Talking about as it relates to Mr. Clinton's motion.
There's no basis to suppress the stop. I mean, if he wants to go file a motion, he can file a motion, but he
That's your response?
What?
That's your response?
Well, my response is he pulled the defendant over. The defendant was asked to step out of the car. And the defendant.
Mr. Clemens is getting at is that he didn't have probable cause to put no.
What was
I was expecting your response to be that based on his collective knowledge that of the other officers who did so, that those other officers instructed him to pull this vehicle over. Now, what their collective knowledge was at the time these other officers, I don't know.
What was your purpose in pulling the defendant over?
To effect arrest.
Like, why were you attempting to effect an arrest?
It was probable cause for a homicide.
Objection is the foundation. Well, that's why I want him to lay it. That's why I'm objecting.
Were you working with other police officers besides just yourself and Trooper Kaiser that you worked with?
Yes.
All right. And simultaneous with the arrest of the defendant, were other things being done regarding known addresses associated with the defendant?
Yes.
All right. So what was being done with known addresses?
There was multiple search warrants executed. There was surveillance up on addresses. They were looking for a specific person. Over the radio, they called that that person was entering a vehicle at an address that I was sitting in the area for. And when they called him in that vehicle, they asked for that vehicle to be stopped.
Now, prior to pulling the vehicle over, have you ever looked at any photographs or seen the defendant before that day?
I can't recall.
Okay. But it was your understanding that he was a potential suspect in a murder case?
That's correct.
And you were making an arrest of him at that point because he was suspected of being a suspect in murder?
That's correct.
Judge, I think he does have probable cause to effectuate a stop and arrest of the defendant based on his probable cause that the defendant was involved in a suspect in a homicide.
His testimony on cross-examination was he didn't know the individual that he was stopping at that particular time, that he was just stopping the vehicle. And I asked him specifically, So anyone who was driving the vehicle, you were gonna execute a stop of that vehicle regardless. His answer was yes. Now on redirect, when properly so, when asked about foundation, now all the questions center around a specific person, i.e. this individual. When I asked him those specific questions, he said none of that, which is why I made the motion. And I still think it's correct that I would yield on that.
Court has now additional information. There's nothing inappropriate about asking the officer follow-up questions to establish reason for the
purpose of redirect. I get it. But bottom line is this, is that you had a homicide that took place. The police are trying to investigate the matter. According to this officer, a number of search warrants have been conducted and so forth. He was given instruction to arrest the occupant of a certain car. Is that right?
Yes.
And he did so. And in doing so, search incident to arrest and finds this gun on the defendant's person. Your objection is overruled and noted for the record.
Thank you.
I don't have any other questions.
No questions. No questions. Thank you, sir. You missed that.
Thank you.
Judge, may we approach real quick? Okay.
Who do we have over there in the who's in the back right?
Witness case.
Okay.
People call Robert Jones.
Common spelling Robert, common spelling Jones. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please have a seat. The witness box next to me. Keep your voice up nice and loud and speaking to that microphone to your left. When you're ready.
Good morning, sir. Could you please state your name?
Robert Jones.
All right. Now, back on September 23rd of 2023, were you in the area of 17630 West 7 Mile Road in the city of Detroit around 2:30 in the morning?
Yes.
And did something happen to you around that time at that place?
Yeah, I got shot.
You got shot? Where did you get shot?
In the lower back.
And did you see who the person who shot you was?
Not go.
Okay. What did you do after you got shot?
To the hospital.
Okay. Did you get any medical treatment for your gunshot wound?
Yes.
What did they do?
I mean, laying on the grave, so.
Did you get stitches?
No, I didn't know stitches, no.
Okay. Were you released from the hospital the same day?
Yeah, of course.
All right. And when you were at the hospital, did you recognize anyone else that you knew that you saw at the hospital?
Yeah, my whole little car club.
The car club was there? Do you know somebody by the name of Denzel Richmond, also known as Devo?
Mm-hmm.
Is that yes?
Yes.
All right. Do you know whether or not he was injured at all when you were at the hospital?
Yeah, he got shot too.
Well, did you actually see him at the hospital?
Yes.
Was he getting medical treatment when you saw him?
Yes.
Do you know a person by the name of Cornisha Vaughn?
Judge, I don't think that
Yes.
answers the objection of foundation. The fact that he was at the hospital getting medical treatment doesn't show the foundation as to whether he was shot or not. If I heard him properly, the question was, did the other person get shot? And then he answered the question, my objection was to lack of foundation. And then the follow-up questions were, well, I saw him at the hospital and he was getting medical treatment. But that
You indicated the person was shot. How do you know he was shot?
I seen the blue.
And that's where, hospital.
Yeah, the hospital.
Okay.
Did you know or do you know a person by the name of Cornisha Vaughn?
That's a female?
Yeah.
Yeah, but I don't know if I had that.
How do you know?
Our nickname.
What's her name?
Army.
All right. Do you know whether she was getting any medical treatment? Did you see that yourself or?
Yeah, she did the treatment.
Right. Did you see what her injuries were when you were at the hospital?
She was shot in the leg, I think the arm, and may have pierced like the chest area.
Okay. Now, as we're sitting here today, you're currently incarcerated?
Yes.
All right. Is that something unrelated to you being shot, the reason for you being incarcerated?
Yes, I'm there.
That's not because you refused to come to court or anything like that is the reason you're.
No, no.
I don't have any other questions.
Cross examine. Before you begin, hold on, Mr. Sinclair. Good, okay, go ahead.
Yes, sir. Just briefly, what's the reason for your incarceration?
Objection,
Sustained.
Is it related to deputy dishonest?
No.
1 second. No further questions.
Ms. Clemens?
Mr. Dwyer. Oh, yes, you had, no questions, no.
Okay.
Call Officer Andre Gruber.
Sir, please step forward. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. The witness box next to you. Voice of nice and loud, speak to the microphone.
Yes, sir.
Maybe when you're ready.
Good morning, sir. Can you please state your name and occupation?
My name is Andre Rupert, Corporal, Detroit Police Department Special Response Team.
All right. Now, on October 13th of 2023, did you have a reason to go to 35461 Elmwood Court in the city of Detroit?
Yes, sir.
And were you there with other police officers?
Yes, sir.
And what was your purpose of being at that location?
Executing a homicide search warrant, searching for an individual who was wanted for homicide.
All right. And did you ultimately go inside that address?
Yes.
And when you went inside, did you see any individuals that were ultimately placed under arrest?
Not in that location.
Okay, where did you see that person?
Ultimately, we made a search warrant out.
Objection to the use of weed. Wow. I need to know exactly who's talking about, exactly who's there, what's happening.
You'll have an opportunity to cross examine, but I understand. You can let us know who you're talking about when you say research.
Okay, sir.
I'm sorry. Were you on actually Clinton Township, not Detroit?
Yes, sir.
All right. So just so we're clear, 35461 Elmwood Court, that's actually in Clinton Township?
Yes, sir.
All right. Is that where you encountered any individuals who were later arrested?
Yes.
All right. Now, do you see that person in court today?
Yes.
Point to that person, describe it.
Here with the beard and this like dark colored outfit with t-shirt, white t-shirt.
The record that this is identified defendant Sean Weaver.
So noted.
Where did you first encounter him?
At this apartment complex, my responsibility is to make entry to this location to look for any hostile individuals who may try to cause harm to any law enforcement officers who want to investigate. I was probably the 5th person into the location.
It's trying to explain on the internet.
Made
The
one.
question was, where did the first encounter, and we started talking about what this role was in the search. That's how it's done.
Where did you first come into contact with Mr. Weaver?
In a bedroom on the 2nd floor.
All right. Now, prior to going in that bedroom, did you clear other areas of the house?
Yes.
And so when you proceeded up to the bedroom, where was Mr. Weaver?
He was lying in the bed, face up in his underwear.
Okay. Were there any other people in the house other than Mr. Weaver?
Not that I know of, sir.
All right. Did you see any cellular devices in and around the area? Did you see any cellular devices in and around the area of Mr. Weaver?
Yes.
Describe what you saw.
I saw Mr. Weaver in the bed with the cell phone in his hands.
And ultimately, when Mr. Weaver was arrested, was he arrested along with his cellular phone?
Objection, lack of foundation.
Let me ask you this question. When Mr. Weaver was placed under arrest, where was he taken?
He was taken out of the bed, taken into custody by
So
SRT
objection,
members.
Judge, we don't have any testimony in the record that this is the officer that arrested us. We went from cell phone in hand to when he was arrested.
I think he said he was arrested.
He did say he was arrested. We don't have any information in this record as to who did the actual arrest. I think it's important because it would go to whether it was hearsay information or not, or whether it's personal knowledge as to.
Just hearsay elicited, we can object to that until we get there. Because that bridge we get to it.
There's no personal knowledge for this leg of the testimony. We don't know who arrested him or where he was when Mr. Weaver was arrested.
Were you present when he was arrested, when Mr. Weaver was arrested?
I was present when Mr. Weaver was taken into custody and handcuffs placed on him, yes.
So you physically observed that yourself?
Yes.
And prior to him being placed in handcuffs, you saw a cellular phone in his hand?
Yes, in both his hands, yes.
All right, and so when he was placed in handcuffs and was he taken away from the bedroom?
Yes.
Do you know what happened to the cellular device?
The cellular device was in the bed, left on the mattress.
Okay. I don't have any other questions.
Cross-examine.
Let's see.
There'll be no questions on behalf of Mr. Peterson.
Okay.
Yes, sir, very brief. Hey, how are you?
I'm good, sir.
Good. The cell phone that you saw, in Ms. Weaver's hands, you know, who the, like the subscriber, information, of that cell phone was?
No.
You know whose name the cell phone was in?
No.
You know the phone number associated with that cell phone?
No.
You know who it's his?
No.
1 second, please. No further.
Can you redirect?
No, Judge.
Thank you, sir. You may stay.
People call Detective Sanchez. Richard.
Sir, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Please, Mark. Get ready.
Good morning, sir. Could you please state your name and occupation?
Richard Sanchez, Detective Lieutenant with Michigan State Police.
All right, and how long have you worked for the Michigan State Police?
Approximately 24 and a half years.
Were you involved at all into the investigation into the death of Elijah Jones?
Yes, sir.
As part of your job responsibilities, did you ever go to the location of 3535461 Elmwood Court in Clinton Township?
Yes, sir.
And why did you go to that location?
We were executing a search warrant at that residence.
And what was your purpose in the course of the execution of that search warrant?
To seize and tabulate evidence.
All right, and so did you personally observe any potential items of evidence that you believe may have been relevant to the investigation that you were part of?
Yes, sir.
What specifically are you referring to?
There was phones and clothing in that area.
Okay. Approach. I'm showing you what's been marked as people's proposed exhibit 6. Do you recognize that?
It's a gray tracksuit.
Are those a series of photographs?
Correct.
And you recognize the photographs as being from the execution of the search warrant out on Elmwood Court in the township?
That's correct.
All right. And are those photographs bearing accurate representation of some of the clothing that was photographed and found at that address?
Yes, sir.
People would move to admit people's proposed exhibit 6.
Any objection? No objection to it to be admitted, Judge, but I would object to the detective's statement that the picture depicts a gray tracksuit. I think that's for court to determine, and the exhibit speaks for itself. I'd ask that that be stricken.
Sustained.
Thank you.
They both should defer.
Yes.
Just to make the record clear, why were these specific items photographed?
They were taken out of the closet of that residence.
Okay. Now, also on October 13th, did you have an occasion to go to 3697 Birch Drive in Sterling Heights?
Yes, sir.
And what was the purpose of going to that?
Executed a search warrant at that residence.
All right, and were you present when that home was searched for potentially relevant items of evidence?
Yes, sir.
All right, and were there any items of clothing that you photographed?
Yes.
No. Thank you.
I'm showing you what's been marked as people's proposed exhibit 5. You recognize those photographs?
Yes, sir.
And what are those photographs of?
It's a black Cincinnati Reds baseball cap with red writing.
And do those appear to be fair and accurate representations of the way that hat was found when you looked in the residence?
Yes, sir.
People would move to admit people's proposed exhibit 5.
Any objection?
No, Your Honor.
Oh, I'm sorry.
Admitted.
I forgot to ask you. When you went to the address of Elmwood Court in Clinton Township, do you know whether or not any cellular devices were confiscated from that location?
I have to refer to the report.
Looking at the report, refreshing.
Yes, sir.
Is that his question memory about whether any devices were confiscated?
Yes, sir.
Was a device confiscated?
Yes, sir.
Cross-examine.
Good morning.
Good morning, sir.
How are you?
Good, thank you.
As far as you know, how many cell phones were confiscated from that location?
I was looking at that report, there's multiple iPhones and I believe a Samsung.
Just roundabout, if you're able to regulate how many iPhones you need.
What I can remember from seeing that, not accurate, but about 3.
Okay, and you know how many like non-iPhone phones were competency?
I just remember seeing the Samsung,
Okay, so maybe 4 total?
maybe more or less. I'm not real sure. I have to look at that report again.
Fair enough. Fair enough. Okay, and the zip up kind of sweatshirt that you took from that residence, you know whether or not, what's your connection to any other information that you have in the case with that specific?
Repeat question, please.
How was that sweatshirt? Never mind. Straight there. 1 second. What kind of hoodies did you take from that residence? Was it a zip up or was it a pull up?
You need to speak up, sir.
What kind of hoodie was taken from the residence? Was it a zip up or was it a pull up?
I have to look back at that picture, that photo.
Can I see that? Did you show right here? So Judge has it approach or the court can show.
So exhibit number 6, maybe another council. Oh, exhibit number.
And what do you see? What are those pictures showing?
It was a 3/4 zip from the top. Upward down.
Does it fairly accurately describe or depict what you saw when you took it from the residence?
Yes, sir.
Okay. As
Anything else from the defense?
No, thank you.
Anything else from Sinclair? Can you redirect?
No, Judge.
Sir, you said there were 4 phones that were confiscated from that location?
Approximately, Judge. I have to look at the report.
Do you recall exactly where they were confiscated from?
Now without looking at my report, sir.
Would that impress your recollection?
Yes, sir.
That is report available.
If you have the tabulation, is that the one that you're looking for? This is on way. I'm ready when you are, Your Honor.
Okay.
We're talking about the address of Birch Street.
Yes.
With Birch Street, there's a black iPhone found in the master bedroom on the floor.
That was it?
That was one of the ones, Clinton Township. The other address is Sherman Heights had multiple phones.
Oh, okay. All right. Any questions based on my question? No, good. No. Thank you, sir. You may step down.
Thank you.
Chat.
There.
Sir, please raise your right hand. Swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. The witness mark. Next to me. Maybe give me ready.
Good morning, sir. Could you please state your name and occupation?
My name is Chadwick Bloom, and I'm Detective Sergeant with the Michigan State Police.
All right, and were you involved in the investigation into the death of Alicia Jones?
Yes.
All right. As part of your investigation, did you look at any cellular devices or cellular phone related evidence?
Yes, I did.
All right. Now, did you happen to be present at 35461 Elmwood Court, I think Clinton Township?
Yes, I was.
Did you see any cellular devices in and around a bed in the second floor bedroom bed?
Yes, I was. There was one device in particular that I was directed to from an SRT member who previously been up here. It was an iPhone that was on the bed. I'm in the main bedroom.
Now, are cellular devices assigned a unique identification number?
Yes, that's called an IMEI number. It's similar to a fingerprint. It's going to be only associated with that device.
All right, and do you recall off the top of your head what the IMEI number was for the device that was found in the second floor bedroom?
I don't call that off the top of my head because that's going to be a 15-digit number. I do recall the phone number associated with that device.
Hold on one second. May I approach?
Ma'am?
Looking at a document professional.
Yes. So this IMEI number is going to be 35256-44920498.
Similarly, did you ever become aware of an IMEI number for a cellular device that was confiscated from vehicle associated with Sean or Mr. Patterson?
Mr. Peterson, yes, I was. Again, that is a 15-digit number that I don't have memorized, but I do have the phone number for that specific device.
All right. And I showed you a document that refresh your memory about the IMEI number?
Yes, it will. And the IMEI is going to be associated with the device associated with Derek Peterson. It's a 313-952-3436 number, and that IMEI is going to be 3546-2790-4893-460.
I don't recall, did you ever say what the cellular, what the phone number was for the cellular device that was confiscated from the Elmwood Court address?
So that's the device associated with Mr. Weaver. That's going to be 313-574-9594.
Now, in the course of your investigation, did you ever obtain any cellular phone records from any cellular providers for those phone numbers and for that IMEI numbers that you referred to here in court?
Yes, it is. So the number that's associated with Mr. Weaver, that's a T-Mobile subscribed number. The number associated with Mr. Peterson is a AT&T or a Singular Net number. And in those phone records, subscriber information is located. Those phone records also provide the IMEI that is associated with that device, which can then be cross-referenced with the phones that are seized, to show that they're the same devices.
All right, and the phone records that you got from the phone company, did that appear typical with phone records that you receive in the normal course of business from these cellular providers?
Yes, the returns were typical. CDRs were requested, time in advance or RTT data is requested, and those subscribers certified the records that they sent back to us.
So they sent you an affidavit certifying that they were authentic and true business records?
In the returns, there's a certification letter that they attach.
Your Honor, at this point, people would move to admit People's Proposal 3, which is a disk contained cellular phone records.
Any objection? Not to certify. All right.
For devices associated both with Mr. Peterson and Mr. Weaver.
Is there an objection?
Both those phones are in the Division 3?
Yes.
Objection. And then?
All right, now those cellular phone records that you receive, do they contain the location of physical cellular towers located in and around the Metro Detroit area?
Yes, so with the T-Mobile records, when those returns come in, the tower records are included in that. So the program that I use to map the records, it's included with the returns for the CDRs and the time advance. With AT&T, we obtained the updated tower list, and that's input into the program. So that tower list is provided by AT&T.
All right, and so you say put into the program, what program are you?
So the program that I'm proficient in and trained in is called CASP. That's a FBI program. I was trained by FBI agent George Reinhardt and Brian Toltitz, and I've been using that program for approximately 18 months.
So if I understand you, you take the records that are provided by the cellular phone company and then plot the geographic location of the cellular towers into that program.
So it's kind of like a drop entry, a drag drop entry. So you put the records into the part of the software, it loads it, and it automatically plots for you. It takes the physical input of each lat and long that's obtained by the cell phone company, and it does it automatically. The only thing, I do the interpretation of what it appears to be showing, and I make sure that the correct UTC time for that time of year is input as well. In this case, it would be UTC -4 for Michigan.
So did you ever look and see what towers that these cellular devices were connecting to at around 2:30 in the morning on September 23rd of 2023?
Yes, I plotted and reviewed the records for the entire day, and then I generated a report based on the information from the investigation.
As part of your report and investigation, did you print out or at least select a number of maps that visually represented which cellular towers that these devices were connected to around the relevant times?
Yes, I did, and in those is also included RTT data and time in advance data plots, so it will show tower connections and records plotted, which is basically your phone's always connecting, where the service provider is always trying to connect with your device. And in doing so, you don't need to make a text or call. It will send out a signal, and it's like a handshake between where it believes the phone is at and the next tower. So it will give us an approximate location of where that device is, regardless of the call or text.
And so, let me approach. Showing you a document that's been labeled People's Proposed Exhibit 4. Do you recognize any of the images on that multi-page document?
Yes, I do.
And what do you recognize those as?
So we're going to have tower connections in two separate locations here. The bottom tower connection, which you'll see is this 120-degree tower connection, which suggests that the device is connecting with this side of the tower. So that's going to be an approximate tower location. The pink blocks are going to be the time in advance, that handshake I was talking about with the subscriber trying to connect with that phone, giving us an approximate location of that device. The bottom one here is an area off Grand River Boulevard. It's going to be west of the Southfield Freeway. And the top one up here is going to be at 7 Mile Road, just east of the Southfield Freeway. And in this orange plot that I have in this diagram is the location of the incident.
So which cellular device that is associated with page 1 of People's Exhibit?
This is going to be the device associated with Sean Hoover.
Now moving to page 2. What is supposed to be represented on page 2 of this exhibit?
Page 2 is, again, a stick image from this program. This is showing a CDR, which is a call detail record. And what it's doing is it's showing the phone that made the call, who the call was placed to, and the duration of the call. And what this is showing is an outgoing call at 1:52 in the morning to the device, from the device associated with Mr. Weaver to the device associated with Mr. Peterson for a duration of 38 seconds.
And does this phone call, does it show up on both sets of phone records?
Yes, it does.
Now looking at page 3 of Exhibit 4, what is the significance of that image?
So this again is a stick image from the program which shows the records associated with Sean Weaver. In this image, I have a red box around one plot. That plot is the first plot that gets into the area. So that's the first record produced by that phone company of Mr. Weaver's device getting into the area. And that was at 1:59 and 45 seconds on the day of the incident. The continuous numerous plots there are going to be records produced by the device in the immediate area of the incident. And then this specific photograph includes from the time frame that I had mentioned, 01:59:45 through 2:29:38. And in the blue box at the bottom, that's going to be the first record produced at around that 2:29:38 time frame, where the device is now moving away from the scene definitively.
Now looking at page 4, what's the significance of that image?
So this image, this is going to be generated, again, the same program that I use to map phone records. This will be associated with the AT&T records. That's why they're slightly different in appearance, associated with Derek Peterson's device. It's going to show an overlay too of Mr. Weaver's records. So the green plots in here are Mr. Weaver's records. The tower connections and arcs are associated with Mr. Peterson. And as you can see, the records do reflect almost a mirroring. So they'll move in the same manner in the approximate same time frame up to the location here of the incident. And Mr. Derek Peterson's records appear to connect the tower just to the west of the Southfield Freeway, 7 Mile, at near the same approximate time, 01:59, the day of the incident.
Now page 5 of Exhibit 4.
This is going to be again an image that associates both plots of phone records. After the incident occurs, the shooting occurs, we'll have the first clear movement away from the scene by the records associated with Mr. Derek Peterson's device around 02:26, the incident occurring at approximately 02:25. And in addition, those same green plots from the AT&T records are included, and they appear to be moving in tandem together, mirroring the same route leaving the scene.
I think I may have failed to move to admit this, but I would move to admit this proposed Exhibit 4. So I don't-
Any objection?
Objection. I'd like to have change cross-examined before.
Okay, go ahead.
Started, so, chat, excuse me, program that you're familiar with working with, CAS, VIZ, CAS Viz?
Yes.
Okay, so that program, when you use it and it plots a map, it will give you a confidence score, isn't that correct?
There is a high, low, and medium with the records, with the plots in association with the T-Mobile device.
Right.
T-Mobile records.
Okay, so whether using T-Mobile or AT&T, the fact of the matter is that this program, like you said, does give confidence scores, correct?
Yes, to a degree.
All right, and do you pay attention to those confidence scores when you're mapping?
Yes.
And when there's a low confidence score, what do you do?
That stays in the report. I don't remove or edit anything that's produced by the device.
Okay, and if it's a medium happen score, same thing, you don't edit it, you keep it in your report.
Correct. There's no way for me in that program, for me to physically, the way that I utilize it, to physically remove or edit specific records, nor would I, because I want to keep the records as they are.
Right, so for instance, on page 1, you testified that that sector that's matched in the left lower corner, you said that was Sean Weaver's phone in that location, correct?
So yeah, well, I'd have to see what specifically you're talking about to comment on it for certainty.
May I approach and ask questions for this microphone?
That's fine.
Thank you. So this was the same, this image is the same as what you had for exhibit for page 1.
Page 1, correct.
Okay. And you see this representation of the sector in the upper right hand corner.
Yes.
Right? And that is the 7 mile. Is that right?
Yeah, that's going to be the approximate location of the incident.
So looking at this sector, then would you agree that on page 3, this is the same sector that is in miniature on page 1?
Yeah, it's just a zoomed in portion, and depending on what's noted in the report, the times should be in there. And in this specific one that you have up is 01:59:45 to I believe it was 2:30:36. Yeah, that's it.
Okay. So on this sector, would you agree that the software has given this image saying that description automatically generated with low confidence?
Where are you getting this?
From where I'm hovering.
So there's multiple plots there. There's dozens of plots, and so all those plots will give individual confidences of low, medium, and high. And it's the consistency of them being in that area would suggest that that device is in that immediate vicinity.
Okay, even though the basically you don't do any work, it's charted by the program, correct?
It is charted by the
And the
program.
program generates a chart, and if they say that the chart is generated with low confidence.
That's just one minor part of it. You would have to say that it's low confidence if you included the probably 20, 25 different plots in that location.
Wouldn't you agree though that plots outside the shaded sector are not reliable?
No, I would disagree with that.
Okay.
And part of what we do to check on reliability would be to see if there's a video of the person on the scene or something that's associated with the person on the scene. Which I believe was covered with a photograph of the vehicle that was associated with that immediate area.
Yeah, the phone's not. The phone's
The
not
phone is.
associated because it's
So
just low confidence. So
No,
low confidence,
that's-
what would that mean?
that's
Like
it.
10%?
No, that's incorrect. So basically what you're doing is you're taking out of, let's say, a basket of 20 marbles, you're picking one that says low and saying it's associated with all, it's not.
Okay, so here, these dots, representing this repeater outside of the shaded sector, these all say generated with low confidence, correct?
They don't all say that.
Please.
So is this right
Please,
here?
this sector, please find one that doesn't say those.
This is a PDF. This is the actual program pulled up. I
But
can,
this PDF, which I've never received anything like this before, because I don't think they were provided these copies. Because this chart where I'm hovering it says low confidence is new. And the dots outside the sector also say generated with low confidence.
well, I can tell you with absolute certainty, they all do not say with low confidence.
I said,
I would have to,
please take a look.
this isn't the program. ma'am.
Okay. But
This is a
this is a
PDF
chart.
image.
This is a chart, it's not a PDF image, because it's readable, like, you can read it, says low confidence. So it's not just a.
We could pull up the phone records and cast it is right now, and I'm promising you, they're not all low confidence.
You would need program to be able to chart,
Correct.
because you don't chart yourself,
I use this program. This is the program that's used in that program.
you don't chart yourself. The program.
I interpret what the program,
So when the
provides.
program, says low confidence, how do you interpret it?
If that's, again, it's based
If
on,
that's the case.
Give an opportunity to ask.
so you have to take in the totality of all the plots. I wouldn't just pick one plot that says low confidence and say, oh, this is unreliable, when I have a dozen or 2 dozen plots that say medium confidence, high confidence, again, low confidence, high confidence. Those all have to be taken into consideration. And then we get other things, other common identifiers associated with this device to then show, okay, this device is associated with this person. For example, on October 11th, we went and mapped the records and showed this person in the approximate area of what appeared to be a gas station. So we go to the gas station, who's on video, the person that's associated with the device. So there's multiple things that go into it. Again, in my reports, it will say suggests.
This is not a picture of where he was at a convenience store.
No.
This is where you're saying it's a lot. And the
But there's video of the
dots
shooting.
inside the shooting sector and the dots outside the shooting sector say description automatically generated with low confidence.
It's-
Is that correct? It says that.
That's not the correct interpretation.
But
If you just say
there is that on there, isn't there?
on a PDF, yes, that's not the program.
So, well, so here, when I move over top of the dots charted on page 4, there's no, this one just says description automatically generated. But again, this is the same photo of a sector.
Which says something entirely different, so you're
Says-
relying on one part of a PDF image, which I don't know why it generated that. It's a snipped image from the program, it's not. the
I'd be
program.
interested in all of the graphs that you are introducing or proposing to introduce today, and I'd like to see all of them in terms of the confidence scores, because it's relevant to whether this phone was attached. to the location.
That would not be an issue.
Yeah, I don't get it. This is just a narrative.
Okay, so here, let's move to page 7, where you say, this is it, this is the demonstrative map that shows that Mr. Reaver and Mr. Peterson are leaving the area together. And as I move my cursor and hover over the dots in these sectors, it says medium confidence on each of these, isn't that correct?
Okay. I give you the same answer, yeah.
Okay, first though, answer my question. Do each of the maps appear to say they were mapped with medium confidence per the map item?
For that PDF document, when you hover over it, yes, that's not the program, so I can't say
Yeah,
for certain.
so we're seeking you and person want to introduce this medium confidence map that shows coming and going from the scene. And how do you interpret it? I mean, I understand you have other pieces of evidence, but how do you make a phone present at a location when the actual software charts it as at medium or low confidence?
So I don't make the phone be anywhere. It's what it's the handshake and the tower connection with that service provider and the device. Now, you know, there's factors that can take into consideration on why you might get a low, medium, or high confidence. And it could be, is the phone in motion? Is the phone connected to the tower with a phone call? I would imagine it's going to be a much higher confidence because it's connected, making the call, and you would need a good service connection. So as a phone moves, it's going to give you different confidences. Ultimately, what this map is a suggestion that says, okay, we have these 2 records, and as we're moving in time along what appears to be these different freeways, which I can't say for sure it's on the freeway, right? But it appears to be in that way that they're moving in tandem or together. And that's the best way that I can explain it to you because I don't have video of these devices as a little bit along.
You make a good point. You say it's a suggestion where the phones are, because isn't it true that the software manufacturer that you use to make these maps says they should only be used as investigated leads?
I couldn't give you, the specific, verbatim verbiage that the manufacturer uses, because I personally do not know, what the manufacturer, legally put out there as far as its, certainties are
So this is a program you said you've been trained,
by the FBI,
but
yes.
you don't know the limitations of the program.
I didn't-
Because you've never looked at the manual.
I didn't develop the software. I'm not an expert in creating software, but I can tell you I was trained annually by 2 separate FBI agents who are designated for this district position.
So your training, it sounds like, was learning how to drag and drop files and then wait for it to print and then you have to, yeah.
There's-
That's pretty much.
There's more to it. You're simplifying, which is fine.
Which is what it sounds
Which
like.
is fine, but there's other things that we do, which I already indicated, to associate that device with that person. And it's going to locations, it's seeing somebody on video, it's seeing their cars in the approximate area. And then also when we end up getting our hands on the device associated with that person, cross-referencing that IMEI that's specific to that phone and the phone that's retrieved. So I can say for certain that the records that are mapped here have a specific IMEI, and when Mr. Weaver and Mr. Peterson were taken into custody, those phones in their possession are the same ones to these records.
The records that show medium comments.
In this PDF document,
Right, so. Would you, okay, so when you did your, extraction, it was with Bray key first, correct?
I did not conduct the phone extraction. Detective Sarah Marvel of the Detroit Police Department.
Okay, so I just want to back up so before I understand, in order to get to the cell phone records that you can load into the software, it needs to go through a couple processes, correct?
So the cell phone records are sought with a search warrant, which are requested directly from the service provider. They then return that information to the OIC, who requests the records. Any information associated with the device itself, as far as the forensic download, that's the grade key, the Cellbrite Premium software that then gets put into a report for us to interpret.
Okay, isn't magnet axiom typical with the software for the Bray key cracking tool?
Judge, I'm just gonna object. Now it seems like we're going to.
Sounds like cross-exam, but you had questions to the school.
Yeah, I did.
So are you objecting to it?
I am objecting, for that, yes, we.
On what basis?
On the basis that the document shows not evidence of where the phones were located at in terms of the purpose of its introduction. The purpose of the introduction would be that it is a suggestion, as the witness put it, the suggestion of where the cell phone records may have been.
Sounds like your objection was more to what weight we should attribute to evidence as opposed to its admissibility.
Yeah, I'll just report.
Yes.
So, all right.
I just have a couple more questions.
I didn't finish my. Oh, I see, this is just for here. I apologize. Where did you go?
All right, officer, so if I understand your testimony, based on your review of the phone records that you were provided by the phone company, both of these devices with the phone numbers that you testified about were in the area of 17630 West 7 Mile Road, approximately 2:15, 2:30 during the time in question.
Yes.
Now, did you ever become aware whether any fired cartridge casings were recovered and placed on evidence from the scene?
Yes, I was.
Do you know whether any of those, the fired cartridge casing as well as the firearm that was recovered from Mr. Peterson were sent to the state police lab?
Yes, one cartridge was associated with the device which Mr. Peterson was in possession of when he was stopped and arrested for DC for his crime.
I don't have any other questions.
Sorry, you said device?
No, the arrest for bringing Mr. Peterson in, the weapon was on him, and that was a match by the MSP lab from one case in recovery system.
All right.
Does that would be hearsay? I actually, for him to provide that testimony, unless he's gonna move to admit the report now. Which I want in, because it proves that Mr. Peterson didn't kill Ms. Jones, so that's fine.
I was gonna move to admit the report later, but I think we could admit it now as he was proposed to age the street safety staff.
No objection, Mr. Coombs?
No, I'd like the report to speak for it, though, not the officer. What's that?
So before the phones got to you, there was an investigation where a geofence warrant was sought first, correct?
I know there was a tower gun warrant. I could not speak to any sort of geofence warrant without reviewing warrants and search warrants.
Okay. So what is TLO?
TLO is a law enforcement open source database where you can input names, addresses, vehicles, phone numbers, and get the returns for any information that's out in the world, out on the internet, or with, in some cases, telephone providers have information on people that are associated with us. We try to find out whose number is associated with or who's associated with a number. We'll give a return, the percentage, who's associated with an address. There's a return of people who have email accounts, phone numbers, actual state of Michigan, ties with Secretary of State, with addresses. There's a lot of information that you can obtain.
All right. So do you recall that it was Mr. Weaver's phone that he first observed my client's phone number 952?
So that phone number was first made aware to me from the agent Wojcik, the federal probation officer.
Did you use TLO in this case to get personal information of your inclusion?
Derek Peterson, no, I used ZX, which is another similar thing as a law enforcement open source database. Your credentials for me are verified, so that I am in law enforcement. You input a phone number and it gives you the subscriber information. I believe possibly the effective date, but Derek Peterson's number in ZX is associated with the 313-952-3436.
Okay. So is that, you say, operate the same way as TLO pretty much?
Similar, I don't use it as extensively. I use ZX primarily to help confirm or, again, produce a possible lead who's associated with that phone number.
Does ZX do skip tracing?
I could not tell you that.
TLO does.
Again, could not tell you that.
Okay. And then there was a first search warrant for Mr. Peterson's phone records, which he wrote, or he decided to put him in the area at the time of the homicide. So there were records that came from the first search warrant, and then there were records after the phone was seized. And the second IMEI was developed on that phone once it was seized, right?
So the search warrant that sought for the phone records from the service provider, in Derek Peterson's case, those come back. It was associated with either an iCloud or a Gmail account of slip P42, but also with his name and the subscriber information, Derek Peterson. The date of birth, I believe, 19 975 or it's something like, don't quote me on the address, sorry, I'm trying to remember all of it. So that was associated with that phone number from AT&T from the service provider itself. Then once the forensic download of the actual device is done, that's compared to the IMEI with that phone number in the actual device itself. They're the same. So that says that this phone was the phone that was producing these records. So I have records being produced at the scene of the homicide that same IMEI, same fingerprint in the defendant's possession when he is stopped and arrested.
Okay, and when he's arrested, he's driving a silver Range Rover, is that correct?
Yes.
And there's indication that this may have been similar to this Range Rover that was observed leaving the scene.
That's what I was made aware of. I was personally not the one investigating the cars and following the cars. I was Sergeant User.
Okay. There were, in the report, it says that as the records were produced, detectives plural mapped Mr. Peterson's phone with the date of homicide. Why detectives plural?
So I mapped them myself, but what I also did was I sent both the records and for both subjects to Special Agent Holtz's and asked him to make a draft so that we have the person who taught me how to do records, the person who's the lead FBI contact for doing this type of stuff to reflect that, yes, they are interpreted the same.
So the records is, and it's reported to detectives means just FBI?
No, so I did all the CASVIZ mapping that you will see in the report.
Okay.
I did that.
All right, so that's a mistake when it says DPT detectives and sheriff, sorry.
Well, it wouldn't say DPD detectives.
It
It
says.
just says detectives probably. That's probably just how I worded the word for word.
Okay. All right. All right. So Celebrite was used as the cracking tool for the break records, is that correct?
I couldn't tell you because I was not the one that cracked the phones. It would have been either with Breaky or Celebrite Premium, but the forensic downloads were put into a Celebrite reader report.
Isn't it true that when developing a Celebrite report, that the creator of that report who dictates what searches are seen or what searches are made during the extraction?
Are you asking, can you repeat the question just so I have it?
Yeah, so Celebrite reports can be limited to what the user inputs as searches into the Celebrite software.
You could, so I think what you're getting at is, so we're gonna get all the information that this program can recover from this device. Now you can specifically search certain things. You can search, you can analyze the timeline. You can look at all media files, all SMS, all native ones, all social media messages, phone calls, FaceTimes, keyword search. I could sit here all day if I had a long enough list to tell you the different types of searches you could do.
From that raw data, though, a Celebrite report is created, and in that Celebrite report, whoever created that Celebrite report has searches that they may have done that were relevant to their investigation, correct?
So whoever is searching that Celebrite report, I guess I'm not understanding what you're asking.
I'm
Can
asking
somebody
you.
search the Celebrite report?
I'm saying that when a user creates a Celebrite report, that Celebrite report is friendly to that user. That user put in specific searches that were vaguely relevant to the investigation, and that is what you see in a Celebrite report, rather than the entire raw data.
So everything that the Celebrite program is able to grab from that and is put into a report, there's a hash number that's associated with that. And that hash number is included into the reader report that the detective, whoever is going to review that report, gets. That hash number is going to be the same as the hash number done by the downloader to show that there was nothing changed with the device, there was no tampering or tinkering with. As far as If one detective searches, and if it doesn't change the subright dump or program, is you can conduct an unlimited amount of search and then return the file back to the state.
However, the celebrate report does not include all of the wrong data.
It includes all the data and all the unknowns that it can, so it is getting everything that this program can currently extract from the device.
There is indication that first responders were responding to a shot spotter notification. Did you hear about that?
I couldn't comment on that.
You didn't.
Yeah, I could, sorry.
So the criticism of that software that you use, CASPIS, is that one, it's constantly collecting vast amounts of data and it's importing them into the program so that there might be errors with the data that's received. Have you heard criticism for it?
Hi, now.
Objection, Your Honor. Again, she's just testifying. It's an inappropriate question.
He's presented as an expert, and I'm asking if he's familiar with the criticism of the program you specifically use to chart locations.
You can rephrase it.
Thank you. Are you aware of criticisms of CASPIS software?
Related to that program specifically, I'm not aware of any particular circumstance.
Okay. Has it been peer reviewed outside of law enforcement?
I can't speak on behalf of what the FBI developers have conducted as far as that goes.
But it is only available to law enforcement, FBI law enforcement.
As far as I'm aware, yes.
And your training was limited to this specific program. Is that correct?
I've been trained in cell phone forensics, smartphone technology. I'm a certified Cellbrite operator and analyzer. As far as CASPIS goes, it's what I'm specifically more proficient in. I did learn how to use the program DART, but it's not what I use on a regular basis in my investigations. This is the main program that I use.
Okay. All right.
Can you redirect?
No, Judge.
So you may start.
Thank you, Your Honor.
A few items of housekeeping, Judge. I'm also moving to admit people's proposed exhibit 9, which are certified medical records for patient Cornisha Vaughn.
No objection. Admitted.
I'm also moving to admit people's proposed exhibit 10, which are again certified medical records relating to patient Denzel Richmond.
Any objection?
No objection.
Admitted.
With that, Your Honor, the people would move to bind the defendant. Oh, I believe there's also stipulation for purposes of the preliminary exam only that both defendants had previously been convicted of felonies and were ineligible to possess a firearm at the time of these alleged offenses.
So stipulated for exam purposes only? I didn't see. I'm sorry?
I just stipulated that, I didn't see the.
Ms. Clemens?
I just need to know what the prior felony is, and I'll stipulate it.
This is prior.
Yeah, I'll stipulate for exam purposes, obviously.
This is certified record.
All right. Admitted.
With that, Your Honor, people would move to bind the defendants over and reserve our hearing.
Mr. Sinclair.
Yes, sir. I object to the bind over as relates to Mr. Weaver. There is not information in this record that Mr. Weaver was in possession of a weapon or had a weapon that fired a shot that caused injuries that have been ascribed or associated with him.
Let's cut to the chase. If we said there's no information that he did what?
That Mr. Weaver was in possession of a weapon.
Did you see that in the video, or what looks like at least strong circumstantial evidence that that was him, one of the two shooters that was out there shooting?
Well, there's no testimony that came from the chair that said that Mr. Weaver was the individual that was in the video. We did see a video, but that, like I said, there's no testimony that says that was Mr. Weaver.
No, we saw a video, and then the court has also been presented with a number of exhibits that shows the clothing of the person who looked a whole lot like Mr. Weaver, except for the beard that he was wearing on that day was a little longer. But aside from that, it looks exactly like the defendant that sits before this court today, in addition to the clothing that was allegedly taken from his residence or a place that he was at anyway, that matches exactly what I've seen in the video and his exhibits.
But I know for the record that the video is black and white, and then if the court looks specifically at the, I'll call it it was testimony that it was a three-quarter zip sweatshirt. That's not the same.
Who said it was a zip sweatshirt?
The one, I had to look and see what his name was, one of the officers that testified. What's his name? Sanchez.
So, no.
Because that's when I asked to approach and I got the pictures and he said, he described it as a three-quarter.
So I'm looking at the people's exhibits, namely,
I think it's exhibit 6, if I'm not mistaken.
there's exhibit 6. There's a better picture of it. Exhibit 4. Those zips sweatshirt there.
Well, I can only go by the testimony that came from the stand judge and the testimony that came to the stand that described what that officer
Even
actually.
in exhibit 6, it doesn't like the zip sweatshirt.
There's an additional picture. I would have to ask the court to approach to point out the picture that was showed to the witness.
Show me a zip sweatshirt. Come on up.
That's the picture that's shown.
I'm looking for, where's the zip on this sweatshirt?
That's the picture that was shown, and that's the testimony that the officer provided.
How much that? So I pull up me. Unless you're mistaken, that string is hanging down as a zipper.
I'm not mistaken, and just going by the testimony that the officer offered, understanding. Need to get those top 2 pictures to see what that person was wearing at the time of the.
It looks exactly like the other exhibits.
Well, I guess I respectfully disagree with that. That's that picture has a zipper all the way down in front of it. And the one that what picture? The one that I just showed.
I wanted you to show it to me. Come show me a picture with the zipper. Where you see it? Here's a frontal picture. You see a zipper here? I'm trying to beat me up with this story. Y'all saw that?
By any means necessary. I can tell that picture. I think that's the one. That other picture.
The frontal picture.
I can tell.
You can't see it. That's what you can't see.
Look at.
Go ahead. That's all. Finish your argument.
No, you want me to, I'm up here. Come on.
I want to see. You still haven't shown me a zipper. That's not a zipper. No, I don't see that.
That's the difference.
I guess that's what makes it a question of fact to be determined by a trier.
No,
No zipper there.
No, it makes it a.
In addition to that.
Well, can I finish my body of argument?
Go ahead.
It's not a situation that creates a question of fact. It's a situation of looking at the picture and seeing what's playing in the picture.
You're imagining things. Go ahead.
I'm not imagining things. I don't hallucinate. I'm in my right mind. I got my good glasses on again. Stand.
I might see with those glasses.
You want to see them? Give me a approach.
Yeah.
All right. Here. Come on.
Maybe these glasses reveal something I can't see.
look through my glasses and look at the picture and see what you see. Be careful, they look fragile, they're reference.
It's very expensive, right?
Absolutely. That's another reason I want you to be careful. I can't see good without them, so be careful. Look at what I see. That might be what I see as zipper, or can't see it.
I still don't see it.
We're gonna have to schedule a funding church.
No, you need a new prescription.
No, it's good.
Absolutely not. Go ahead.
Well, all right, so the picture from the video, one second. Yes, sir. All right, yeah, so through my glasses, my expectation was that the court would see that that there was a zipper present on the picture that was shown in the the security footage, and there's no drawstrings on the shirt that was pictured on the security footage. But I think, Judge, the larger point is that there was no witness that testified today that said that that individual on the actual video is the person that was sitting in court today. The court said that the people look similar.
If they did that, then you'll be jumping up and screaming.
Absolutely, that's my
That
job.
would be objection.
That's my
So I
job.
wouldn't expect them to do that.
Well, the law does allow under certain circumstances they can, but those circumstances weren't present for in order for the prosecutor to present that information. There's some foundational requirements that could be met in order to do that. But like I said, that foundation was not established, and I'm assuming that that's why none of the witnesses were able to look at the video and say who the individual was in the video. Now, the court made the statement that that the individual on the video looks similar to the individual present in the courtroom today.
That's a lot like me.
Yeah, but I would just ask the court not to make a decision based on who looks similar, and just make the decision based on the information that came from the witnesses that testified from the stand.
In addition to the similarities, the clothing that was recovered, the cell phone that was recovered out of the location that he was at, that he allegedly had in his hand, it also pings him at the same general location on the same day and at the same time.
But Judge, my point to my observation as it relates to that is his alleged presence in that situation does not make him the shooter. An observation that we can.
Not by itself, but when you take the totality of the circumstances. Him wearing the exact same clothing, the exact same hat.
But we don't have information that the exact same hat was looking at, based on those pictures that were taken at the residence where Mr. Weaver was found. There's no picture of a hat that matches the hat that was in that.
Are you sure? Have you looked at people's exhibit one?
The ones that I saw didn't show it.
You might want to take another look. Get your Mr. Blue glasses up. Take a look at number one.
Well, I don't really wear Mr. with blue glasses, but Cartier is my preference, and that's what I rock with.
Exhibit 3.
Like I said, I don't wear
those
those
exhibits.
more strips. I'm assuming you from Detroit, you know, Cartier.
Yeah, Mr. Ledoux can't afford those.
Right, so I'm not wearing glasses. And that's not the same hat, Judge. But I'll wrap it up. I'll wrap it up because I don't feel like being told my glasses, I wish with blue glasses and all that kind of stuff. You know, not really feeling it for today. Just could afford what I got. But yeah, so the information that's present in the record doesn't establish the connection that's necessary, in my view, to establish probable cause that Mr. Weaver was the individual that was present on that video. The information as it relates to the cell phone information is that there were 3 to 4 cell phones that were recovered, and the analyst that received the cell phone is not in a position to testify as to where those cell phones came from. He can only talk about the information that he was able to collect from the cell phones themselves. And to that point, there is no chain of custody that has been established today that shows that the cell phone that was collected from the location where Mr. Weaver was arrested is the cell phone that the Mr. Blue, I think it was, received and analyzed. So hold on one second. Yeah, so that's my argument, Judge, and I would ask the court to make its mind of a decision based on the information that came from the seat and not things that were derived from a lack of glasses or Mr. McClue's glasses or anything like that. Thank you so much.
Mr. Garza?
Well, Judge, I would submit that anyone, the court or a fact finder, a jury could simply look at the video. There's a clear shot of a person that we are arguing is Mr. Weaver, and identify him solely based on the video that was entered in court. But it's not just the video of the shooting itself. It's also the clothing, which matches the clothing of one of the shooters. It's also the cellular phone evidence that puts his device around the area, communicating with his co-defendant prior to the murder. Certainly, there's a circumstantial basis for a question of fact as to each and every count. I would also note that the lab report indicates that while a number of casings were recovered, only one of the casings that were recovered matched the gun recovered from Mr. Peterson. That is supported by the evidence on the video where you see clearly Mr. Peterson shooting once, but you can clearly see Mr. Weaver shooting multiple times. So the scientific evidence is supported by the surveillance video. And I would also urge the court, when you're thinking about, is this first degree or something else? You can see both defendants prior to the initial shove that kind of precedes the shooting. Both defendants kind of body up to one of their targets, and you can see them both reaching in their clothing and ultimately retrieving a firearm. So they clearly were thinking about shooting prior to the guns coming out and the shots being fired because they were readying the guns prior to bringing them out of their clothes. So I respectfully would suggest that regarding Mr. Weaver, it's certainly.
So let me first apologize to Mr. Sinclair. I didn't mean to hurt your feelings about your glasses.
My feelings are not hurt, but I appreciate it.
While we're talking about Mr. McClue comments, so I must have hurt your feelings. My apologies.
My feelings are not hurt, but I appreciate the
I only mention that because when I look through their glasses, it looked like a pretty strong prescription. It is. I can see you about it. It's too good because you're seeing things in that exhibit that I don't see. I don't see the zipper on the jacket. People's exhibit 1, which clearly shows a frontal picture of the person who appears to be the defendant, Mr. Weaver, or in people's 6, again, no zipper. But I say all of that to indicate that if you look at each piece of evidence individually, you may have an argument, but looking at them in the totality and how they piece together, you have 2 men there, and quite frankly, it doesn't matter who fired the fatal shot. They're both standing there, they're both firing shots, and they're both acting in concert with one another. They're both aiding and abetting, regardless of who fired the fatal shot, it does not matter. We know that the law indicates that any amount of aid or assistance one gives another in the commission of a crime, that person is just as guilty as if they did it themselves. So there's no question that what we have here is a first-degree murder, premeditated, because both of the people depicted in that video had ample opportunity to have a second look before they took the actions of pulling the gun out and firing multiple shots and hitting innocent people at a crowded establishment. I think it's absurd that this kind of stuff even happens in the first place, but nonetheless, we have a young woman that was killed, Alysia Jones, doing nothing but mind her own business, presumably, or it looked like getting food, and then have to lose her life for this kind of foolishness. What? Acts of cowardice. In any event, there's no dispute as to the crimes that are here. There was a first-degree murder, premeditated assault with intent to murder. The alleged victims, the medical reports were submitted for, as well as the autopsy report of Alysia Jones. What is at issue is the identification of these two defendants before the court as being perpetrators. So what evidence do we have that's relates to Mr. Weaver? And I'll address Mr. Weaver because that's what we're talking about first. Have Mr. Weaver in clothing that appears to be some kind of Nike sweatsuit. What's recovered at Mr. Weaver's location when he's arrested is a Nike sweatsuit, along with a hat. Looks like an aardvark on it that says baller in the front of it. And you can see in the other exhibits, People's Exhibit 1, looks like the same style hat. Because I paid close attention to the square of the baller that encases the aardvark. That appears to be the same design in People's Exhibit 1, along with the Nike sweatsuit that was recovered, which is a Nike pullover sweat jacket and Nike pants. What's distinctive about that Nike sweatsuit? Happens my exhibits. Did you take it? I can take it. I'm sorry. I need some glasses. That's enough of the glasses, Joe. All seriously. All right. What's distinctive about this Nike sweatsuit is the black outlining of the pockets, notably on the jacket as well as on the pants. That's depicted in the video as well as in the sweatsuit that was recovered at the location where the defendant was arrested. That would be in People's Exhibit 2, as well as People's Exhibit 5. And that ugly aardvark hat. And it's also recovered from the same location. In addition to that, it was stated that the defendant had in his possession a cell phone at the time that the officers executed the search warrant. That cell phone subsequently was found to be in the same location of where the shooting took place. I think looking at these matters, the totality of the circumstances, we have more than ample evidence. The circumstantial evidence doesn't mean that it's bad evidence. In fact, circumstantial evidence is more persuasive than direct evidence at times. Looking at the totality of the circumstances, this court is satisfied that people have met their burden of probable cause as it relates to the charges contained against Mr. Weaver. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe he committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date and time will be December 12th, 2023 at 9 o'clock a.m. The defendant will be remanded to the custody of the Wayne County Sheriff. All right. As to Mr. Peterson,
Judge, I would reserve argument regarding Mr. Peterson.
Mr. Clemens. Yes, John. Thank you.
Obviously, I had an opportunity to put your honor's ruling as it relates to the code of jury, so I'm going to be a little bit more brief than what I had planned to be originally. I know the court has made some factual findings, and I'll respect those. Nonetheless, I want to make a complete record. So if the court will allow me to share my screen just briefly.
Oh, sure. Okay, go ahead.
One of the things that the court indicated in its bind over is that both defendants had ample opportunity to shoot or to walk away or to not fire. So what I think pointed about this particular case is that the decedent in this particular case, Ms. Jones, who the court correctly articulated, minding her own business, standing at a food truck ordering food, she is standing here, right by the food truck. Okay. The defendant, and again, Judge, I'm not conceding that they've identified my client, but for this record and for the purposes of the exam, I'm going to take it as if such the court has made at least a probable cause determination and identification to be met. So I'm going to make argument as if I can see that issue, knowing that it's a trial issue. Okay. So if I can see that the individual in the baseball cap is Mr. Peterson, as Mr. Peterson is walking away, Eliza Jones is alive, unshot, and unharmed. Now, he never pointed a gun in her direction. He never fired a gun in her direction. The only time that Mr. Peterson ever fired a gun is in the total opposite direction of Ms. Jones. it would be factually impossible for him to ever have shot. Now, I knew that from the moment that I got the discovery, and if the court recalls, I was pressing the government on getting the firearms report so I could be 100% definitive for anyone who watches the exam or anyone who reviews the record. This gentleman did not fire a shot at Elijah Jones. He didn't kill her, and he never fired a shot in her direction. So for any finder of fact or anyone to argue that the two of them were acting in concert, the evidence pales in comparison and shows otherwise. The individuals can't be acting in concert and never fire a shot in the same direction. Individuals are accountable for what they do with their own firearms. In this particular case, the only thing that could be argued that Mr. Peterson did was fire a shot in the direction of what I believe subsequent evidence will determine to be Mr. Dixon. And that individual at the time that Mr. Peterson fired a shot was not standing near Elijah Jones at all. And the moment that these individuals start going in the direction to where Ms. Jones is, he never fires it. So there's just no basis for finding him over on first-degree murder at all. I've never seen a charge where you have someone charged with a murder, where the video evidence definitively establishes that he didn't kill the person and didn't fire a shot in the direction. It is different and distinguishable than if you and I were in a vehicle together and we were both shooting at the same target in a drive. Because that is us acting in concert. That is us acting together. What you have is an individuals who engage in an argument, there's a push, and then there's a shot fired by Mr. Peters for purposes of this record, as I've already established, the identification being conceded. But nonetheless, nothing on the record suggests that he told anyone else to fire any weapons, that he encouraged anyone else to do that. That individual acted on their own, and that individual killed Elijah Jones, not the defendant. And I keep saying this at these preliminary examinations. When we bind over these weak cases on homicides, the only person that it hurts is the defendant. It's great for defense attorneys when we get to go in and look like icons when we get not guilties on overcharged cases. To charge Mr. Peterson with first-degree murder when he clearly didn't participate in the killing, and the video evidence and the scientific evidence shows it. It's just a waste of our time, Judge. It's fundamentally unfair. And I share the court's sentiments with individuals who are innocent and have nothing to do with what happened to them. Being harmed is outrageous. But that doesn't mean that we get to take our justice system and just try to see if we can make charges stick when the evidence doesn't fit. Even if you look at the medical records, Judge, and this is a low standard, every one of the individuals that was admitted to the hospital for medical records as it relates to purposes of the government meeting a threshold or standard for assault with intent to murder, these individuals are treated for abrasions. 2 of them are treated for gunshot wounds. All of them are released on the same day. And it's also undisputed that the defendant didn't shoot any of them. None of them. So again, from our perspective, Judge, we're asking you not to bind the defendant over, certainly not on first-degree murder. He didn't kill any, didn't fire any shots in the direction where anyone was killed. And then second of all, Judge, as it relates to the assault with intent to murder, I'm asking you to reduce those to felonious assault. We don't have any evidence on the record that substantiates that he did anything in terms of firing his weapon in their direction. You want to say he pointed a gun in their direction? Fine, that's that thing. And I believe the record would support that. But the video evidence overwhelmingly exonerates Mr. Peterson. If the court finds it over his charge, I think it'll be probably one of the easiest not guilties I've had on this side. That'll be all, Judge. Thank you.
Well, Judge, first of all, the identity of Mr. Peterson as being one of the shooters is pretty conclusively established by the fact that Mr. Peterson, Mr. Peterson is still in possession of the handgun used in the shooting almost 3 weeks after the shooting occurs. But I put up a still image from People's Exhibit 2, the video. This is at 9 seconds in the video, ending 5428. We are arguing that individual, you can see the explosion from the barrel of the gun at this exact moment. It is pointed, his arm with the gun in it is pointing directly at the head of this target. You have the medical records from Denzel Richmond, which indicated he was shot in the face. You can't say with 100% certainty whether or not that's where his gunshot wound to the face came from. But when it comes to the question of what Mr. Peterson's intent was,
there cannot be a clear example of having the intent to kill. You're gonna point your firearm at somebody's face, pull the trigger. Now, going forward a bit on this video. This is at 10 seconds in the video. Again, you can see Mr. Weaver, who we're alleging is Mr. Weaver, he's firing his gun at that point, but it's clearly aimed in direction of the decedent. And you can also see Mr. Peterson pointing his gun in the direction of the food truck. Now, all I can say conclusively is that one of the recovered casings came to Mr. Peterson's gun, but he may have fired more than once, and we simply don't have the casings that will match Mr. Peterson's gun other than the one casing that was recovered. But I think truly the fundamental question is, did he do anything to aid, assist, or encourage his co-defendant, Mr. Weaver? And when we go back and look at the video, it's Mr. Peterson who initiates the physical confrontation. He's the one who starts pushing the target away. And then shortly thereafter, he's the one who pulls out his gun and shoots first at the target. So he's clearly intending to commit an assault with intent to murder. And he is aiding and assisting his co-defendant in the ultimate death of Ms. Jones. Now, simply because Ms. Jones was not the initial intent target does not relieve the defendants of liability. The intent that they have to kill the target transfers to Ms. Jones, who just unfortunately happens to be standing in the area where the defendants are pointing their guns at. So respectfully, Your Honor, I think it's a question of fact or a trier of fact about how much Mr. Peterson aided, abetted, and helped Mr. Weaver, but certainly it's a question of fact and it should go to a jury.
So again, as it relates to the charges contained in the complaint warrant, there's no question that we have a first-degree murder premeditated, and that's not to say that either defendant intended to kill Elijah Jones, but they intended to kill someone. That intent transferred to the actual victim, that being Elijah Jones. Now, it never ceases to amaze me what a great attorney Mr. Clemens is. And I say that in all honesty, he's a very good attorney. He's able to come up with something in every case, regardless of how bad it looks for his client. He's a great attorney. And I'm not so sure that, in any event, nonetheless, what makes his job going to be very difficult, however, is getting over the aiding and abetting theory, which says that any amount of aid or encouragement one gives another in the commission of a crime. So any amount of aid or assistance or encouragement one gives another in the commission of a crime, they're just as guilty as if they did themselves. I submit to you, by standing there side by side with the other shooter and firing shots, I would say at a bare minimum is encouragement. And then, aside from that, not only are they standing side by side firing, they leave together, according to the evidence supported by the cell phone records. In for a penny, in for a pound. Knew exactly what they were doing. There's no issue as to the identification as to Mr. Peterson being the other shooter that's there. I give him no credit for being a bad shot. There's just as easily been a fifth victim here, or maybe even more. The point is, this was ridiculous. You have all those people out there, presumably there just to have a good time, and then you have these two yahoos pull out a gun and start shooting because of the dispute, because of an argument. What? Just throwing your lives away. Looking at the rest of your natural life behind bars. Despite, and both of you had great attorneys. I don't mean despite you, Mr. Sinclair. Mr. Sinclair is a very good attorney as well. But under these circumstances, and based on the evidence that I've seen, I don't think even the greatest attorney, Mr. Clemens or Mr. Sinclair, is going to help. So far as it's probably cause hearing goes, the court finds that people have met the burden of probable cause as it relates to the charges contained in the complaint form. The court finds those charges were committed in the city of Detroit. The court finds probable cause of this commitment. The court will find it was handed over to Wayne County Third Circuit Court Criminal Division for proceedings. This arraignment also will be December 12, 2023 at 9:00 a.m. and it will be remanded to the custody of the Wayne County Sheriff.
Thank you.
Just a quick question. There's a keep separate in place for the two. What's the, I don't know, like necessarily the justification or reasoning for it.
I have no idea.
Could that?
I didn't know it.
Yeah, would the court consider removing that order?
Why?
Kind of speaks to the first part of my question. There's no reason for it to be in place.
I didn't make that call. I'm not sure if it did. I don't know if the court did. They found necessary to classify something.
Nash, you want that? So, well, I didn't arrange, I wasn't present, but I have heard circumstances that justify, the order.
Advisory.
I'm objecting. I don't think there's any reason why the two defendants need to be spending time together or talking together. So.
And to that same point, there's no reason that they need to be separated, and it kind of casts an interesting light on them individually, and it could pit them against each other. It gives the perception that they're kind of offering one for the other. Is a suggestion that also offers.
So you want me to order that they be able to come in contact with each other?
I mean, it's not necessarily the order that they can talk to each other, but it's just the absence of order says they cannot. Because I'm not aware of any reason that they should not be able to communicate with each other. Based on my review discovery, based on the testimony that I've heard here today, Mr. DeGrazia, of course, has had an opportunity to speak, and I haven't heard any justification that he's offered to support them, the requirement that they're separated.
Do you have any reason why you might want them to be separate, Mr. DeGrazia?
Well, I'm just concerned. It's my understanding that at least one of them might be a member of Bloods. I'm just concerned about them associating with each other, and calling any of their friends on the outside to cause problems.
There's no basis for that anywhere in the written video record on the that came from the witness stand or anything like that.
You know, for a bond hearing, I'm not even sure if this is a bond hearing, but it's not limited to just that.
I get that. I'm just saying, like, there's no foundation for that information. It is.
Did you make that up?
No, the officer charged.
There's no basis for the information. And then even if, let's assume for the sake of argument that it's true, how does that make them a danger to each other and they're both in custody?
Not so much a danger to each other, but it doesn't sound like anything I want to touch.
All right.
Yeah, for sure. Yes, sir.
Great job.
Hey, how you doing?
All right, Joe, take it easy. All right, you too.
Thank you, Your Honor.
Good seeing you again.
You too, always.
Come on, in. What do we got?
You're in Tisdale?
How many witnesses?
2.
What you think you can do it?
I'm gonna be.
We got Mr. Hart.
Yes.
You know the answer to that question. And Judge, before we even get started, I want you to understand. These are not Cartier glasses. These are $2.50 readers from Walmart.
You see a thing, there was no zipper on that jacket. I don't know what the heck he was looking at. Not nothing even close to resemble a zipper at all. Make things up, you seeing things I'm not seeing.
Oh, no. We going or what we doing, Your Honor?
Let's do it.
Ain't going well.
I watched Mr. Hart many days. Moving straight to the
You go this way up, Your Honor. And I say this, like, not just the officer, but just.
That prescription was very strong. I couldn't even look through it.
What they do is they
Him and everybody standing next to him. It's hot here.
It is. It is. Because there's too much talking.
Is that what it is? I'm gonna be quiet. That's for yours.
Thank you, dear. Stand next to your attorney. One on the detainer. Did they give anything for the detainer? Go back in your. What do we give them back? I need to, we have one of these, I need to- Go back on that same.
Yeah. Okay, great. All right, calling case 2359918 for state Michigan versus Aaron Eugene Tisdale. Defendant is charged in count 1, homicide, murder, first degree, premeditated. Defendant has a habitual offender for defense notice. Appearances for the record, please.
Good morning, Your Honor. Good afternoon, Your Honor. Anna Bickerstaff on behalf of the people, PA 2215.
Good afternoon, Your Honor. Mark Carter.
Tell me your name for the record, sir. This date, time, step, examination of the records.
Yes, Judge.
How many weeks?
One.
Okay. You have any preliminary matters before you close this?
Yes, Judge, I do have a couple things. I do have a protective order for the court, and I'm going to give it sign.
Okay.
Additionally, there is an amended charging pack that I need to forward to the court. The only change is that the defendant is actually a violent habitual fourth with a 25-year mandatory minimum.
All right.
Okay, that's the citizen.
And other than that, at this time, the people have moved to the admission of people's proposed exhibit number 1, which is the medical examiner's report pursuant to MCL 76611B.
Any objection?
None for example.
Thank you, Judge. And this is the medical examiner's report authored by Dr. Nicole Kroom, CROOM, authored on November 20th of 2023. Autopsy performed on Herman Rodriguez, FERMIN RODRIGUEZ. Autopsy performed on November 12th of 2023. For investigation, the decedent was a 53-year-old male who was found unresponsive and bleeding in a parking lot. He was pronounced deceased at 13:52 hours on November 11th, 2023. In consideration of the circumstances and postmortem examination, in consideration of the circumstances and postmortem examination, it is my opinion that death was caused by multiple injuries in the manner death is homicide. And permission to publish the report.
Okay.
And Judge, I'm sorry, I would also ask for a mutual order of sequestration to include anyone that may be on the Zoom.
All right, ladies and gentlemen out there on YouTube, man, in YouTube, if you are a witness or potential witness, I'm ordering you to log off at this time. There are no witnesses in the courtroom. Thank you, call your first witness.
Yes, Judge. Judge, we also do have one stipulation as to the testimony that Officer Michael Luna would have provided. The testimony would have shown that Officer Luna did respond to the scene located at 3938 Burner Highway, Detroit, Michigan, on November 11th, 2023. That when she arrived, the victim and also that the surveillance video at that location is 1 hour ahead of the actual time.
No objection for it.
The second roll call, Angelina Knapka to the stand.
You should have been number, right? I'm sorry.
36636. Oh, I'm sorry, 366. Oh. Oh.
Please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. And please have a seat in the witness box right next to me. Voice up nice and loud and speak into that microphone that's to your left, okay? Maybe when you're ready.
Thank you, Judge. Can you please state your name for the record? And back on November 11th of 2023, were you at a laundromat located at 3938 Burner in the city of Detroit, County of Wayne?
Yes.
And who were you there with? You say that one more time?
Aaron.
Okay, and who is Aaron to you? How long have you been with this?
A year.
How long?
A year.
And do you see Aaron in the courtroom today?
Yeah.
Okay, can you tell us where he's seated and something he's wearing, please?
On the right side.
Record reflect the witness as identified the defendant in this case.
I would indicate, I'm not objecting to the identification, but I would indicate, hold on a second. I would indicate to the record, the witness never.
Did you see who you just identified in court today?
Yes.
What are they wearing?
Green.
Record should reflect the witnesses identified the defendant, Aaron Eugene Tisser.
Now, were you with anyone else this day?
No.
Okay. How did you get to the laundromat?
No.
What kind of car? And who was driving?
Aaron.
And where were you seated? And do you remember what Aaron was wearing back on this day?
Green.
What kind of?
Sweater.
And how did you get? Let me ask you this: where did you come from before you went to the laundromat? And do you remember about what time you went to the laundromat?
8, 9 o'clock.
And why did you go there?
Phone call to meet somebody.
Pull the microphone down and speak into
Had a
it.
phone call to meet somebody.
Who got a phone call?
Aaron.
To meet someone for what purpose?
To make that call or something. All right.
Okay, you may
Why were were you going, or why was Aaron going to the laundromat?
He had a call, somebody had needed him to come up there,
For what? Why did someone need him?
some transaction.
What kind of transaction? Was he selling drugs?
I was not sure, I don't know exactly.
And did you have a nickname for Aaron?
T,
And was it just the two of you in the car?
yes,
And what happens when you first get stolen?
we had parked in a parking spot.
What happens next?
A male individual had walked to the car, on my side of the car.
And at this time, did you know that person?
No, I did not,
What do they do when they come up? Would that be the passenger side of the car?
yes.
What do they do when they come up to the passenger side of the car?
Kneel down and look into the car,
And what does Aaron do?
looks at the person and asks why he's at his car.
And does the guy respond?
Yes,
What does he say?
he had asked to see if we had anything to purchase,
When you say anything, what do you mean?
some type of narcotic.
And what does Aaron say in response?
Get away from my car,
And what does the guy do at that?
last.
And what happens next?
He walks away and goes in front of the car, around the car.
What happens next?
Aaron had went into drive and we took off and ended up contacting him in front of the car as we were pulling off and ended up running him over.
Who was driving when the victims ran over?
Aaron,
Do you say anything when this happens?
yes,
What do you say to Aaron?
said, stop. He's in front of the car.
And what does Aaron do?
Yeah, he just kept going straight.
At any point, do you try to grab the steering wheel?
Yes,
Was that successful?
no ma'am,
Would it be fair to say you're trying to grab the steering wheel to divert Aaron away from the victim?
yeah,
Now, at some point, does Aaron tell you who this guy is?
not till after the fact,
When does he tell
after the situation happened.
you? Let me ask you this. After the incident, where do you go next?
Home, to Aaron's mom.
And where's home? Do you know that address?
No, I do not.
Or do you know what street it's on?
I don't remember.
Would it be Grandmont Street?
Yes,
Would that be 6821 Grandmont Street in the city of Detroit?
yeah,
So that's where you go after the laundromat?
yes.
And what do you do when you get to that location?
Step off the car and look at the damage of the
And where do you see the damage on
left side of the car, driver's side.
the
Front,
the front?
yes,
And that wasn't there before you went to the laundromat?
no,
Okay, what happens next when you get to that Grandmont location?
yeah. Took the license plate car off the car and transferred it to another car we had.
Who took the license plate off the car?
And
And took it off of which car?
Equinox,
And do you do anything else at the Grandmont location?
no,
Where's the Equinox parked when you get to the Grandmont location?
in the driveway,
Where do you go next?
and the insurance,
Why do you go there?
we had damage to the car.
Does Aaron tell you why he wants to go to the insurance store?
Because it was damage to the car.
You're trying to transfer the insurance off that car?
Yes, ma'am.
Are you trying to put it on another car?
Yes.
Which car?
Volkswagen.
Which vehicle did you take to get to the insurance store?
Oh, the Volkswagen. The insurance.
And does something happen while you're at the insurance location?
Detroit police will
Do what?
handcuff Aaron and asked me to step in the car and arrested both of us.
Now, going back to the laundromat, did you ever see, what did Aaron call the guy that approached the car?
He didn't refer him as to anything until after I was posted.
It's Jose?
Yes.
Back on this day at the laundromat, did you ever see Jose with a weapon?
No, I didn't know him.
Did Jose ever make any threats to you or Aaron in the laundromat? On this day of November 11th, did Jose make any threats?
No.
Thank you. Now, would it be fair to say you're transported to the police department after you're arrested at LA Insurance?
Yes.
Yeah. Yeah.
Did you speak?
Well, I'm sorry, what was the question?
Were you taken to the police department after you were arrested at the LA Insurance location?
Headquarters.
Headquarters?
Yes.
And while you're there, do you speak with police?
Yes.
Now, would it be fair to say you were not initially truthful with police when you spoke to them?
Yes.
Right, and you told them you weren't present, is that correct?
Yes.
And eventually you tell the truth to the police officers, is that correct?
Yes.
That you were in the vehicle at the time of the incident?
Yes.
I'm going to approach the people's proposed exhibits 3 through 6. May I approach the witness?
You may.
You could flip through those for me. Okay. Do you have an opportunity to look through those?
Yes.
And you had an opportunity to look at those earlier today, correct?
Yes.
Okay, do you recognize what those are?
Yeah.
What are those?
Well, can we do one exhibit at a time?
Yes.
Okay, starting with the one that's marked number 3, do you see that picture?
Yeah.
Okay, what's that picture?
Picture of the car and the body laying in the parking lot.
And does that fairly and accurately depict you in that Equinox back on November 11th of 2023?
Yes.
And would that be at the laundromat?
Yes.
This time I moved to the admission of people's exhibit 3
No objection. Transfer.
Admitted?
and permission to publish.
Yes. Let me see that.
Ms. Conrad, put it up on the screen. Do you recognize what's up on the screen here?
Yes.
Do you recognize that vehicle?
Yes.
Whose vehicle is that?
Here.
I'm sorry. This is exhibit 3.
Is that the vehicle Aaron was driving that day?
Yes.
And do you recognize anyone in this picture?
Yes.
Who do you recognize?
The Aaron and Jose.
Okay, where are you in this picture?
Passenger seat.
That be inside the car?
Yes.
And where's Aaron?
The driver's seat.
And you said you saw Jose, is that correct?
Yes,
Where's Jose in this picture?
laying on the ground.
Is that in the upper right-hand corner of the picture?
Yes,
And do you see the picture marked number 4 there?
yes,
And do you recognize what that is?
yeah.
What is that? What's in picture number 4? Or I can take, you want me to take it again?
No, it's okay.
What's in picture number 4?
Dead on the left side, the driver's side of the car.
Okay, do you recognize that car? Does that picture fairly and accurately reflect the car from back on November 11th of 2023?
Yes,
At this time, I move the admission of exhibit 4.
You need objection?
None.
Admitted?
Permission to publish?
Yes.
Do you see what's up on the screen in People's 4?
yes,
And do you recognize that car?
yes.
Whose car is that?
Aaron Tisdale.
And do you recognize anyone in this picture?
Yes,
Who do you recognize?
me, Aaron Jose.
Where are you in this picture?
Passenger seat,
Where's Aaron in this picture?
driver's seat,
Where's Jose in this picture?
on the ground.
Picture of part number 5 there?
Yes,
Okay, do you recognize what's in that picture?
yes,
What's in that picture?
me and Aaron.
Does that fairly and accurately reflect you and Aaron back on November 11th of 2023?
Yes,
This time I moved the admission of People's 5.
No objection for admission.
Admitted?
Permission to publish?
Yes.
Do you see the picture that's up on the screen here?
yes,
Do you recognize that vehicle?
yes,
Whose vehicle is that?
Aaron's.
And do you recognize anyone in the picture?
Yes,
Who do you recognize?
me and Aaron.
Where are you in this picture?
Passenger seat,
Where's Aaron in this picture?
driver's seat.
And do you see the picture marked 6 there?
Yes,
Do you recognize what's in that picture?
yes,
What's in that?
me and Aaron.
Does that fairly and accurately reflect you and Aaron back on November 11th of 2023?
Yes,
This time I moved the admission of People's Exhibit 6.
No objection for admission.
Admitted?
Permission to publish?
Yes.
All right, do you recognize what's on the screen?
yes,
Recognize that car? Whose car is that?
Aaron.
You recognize any people in that picture?
Yeah,
Who do you recognize?
me and Aaron.
Where's Aaron in this picture?
Driver's seat. The driver's seat.
Now, earlier today, did you have an opportunity to watch a video?
Yeah,
And did that video fairly and accurately reflect your time at the laundromat back on November 11th of 2023?
yeah,
This time I moved for the admission of People's Exhibit number 2.
No objection.
Admitted?
Permission to publish?
Yes.
For the record, I paused the video at 15 seconds. Do you see what's up on the screen?
yes,
Do you recognize that vehicle?
yes.
Whose vehicle is that?
Aaron,
Who's driving that vehicle?
Aaron,
And where are you at this time?
passenger seat.
And where is this taken from?
The laundromat, the people, Sinclair highway.
For the record, I'm resuming the video.
Sorry.
I said I'm resuming the video just for the
Okay.
record. For the record, I've paused the video at 1 minute and 33 seconds. Can you see what's up on the screen here? Okay, do you still see the equinox in the video here?
Yes.
Can you tell us where it is, please?
Sorry.
Can you tell us where the equinox is in the video here?
There was hard to stop.
Okay, would that be sorry?
I do argument.
Would that be in the upper right-hand corner of the screen?
Yeah. Yes,
And can you tell us what's going on at this point in the video?
we are hurt, and Jose is at night passenger.
For the record, I'm resuming the video.
Could I interrupt you 1 second, Judge?
For the record, I paused the video at 1 minute and 30.
Oh, I'm sorry, I do see it. I was wondering if there was a clock.
Timestamp.
Okay, thanks.
And for the record, I paused the video at 2 minutes. 2 minutes. I just haven't. Ask the witness.
Cross-examine. I'm sorry, you pronounce your last name Kanako?
Kanaka.
Kanaka. Let's start with some of the stuff you just told us. I hear you say that you and Aaron left the house at about 8 or 9 that morning. Isn't that what you said on direct examination? Yes or no, ma'am?
Yes,
And you went straight to the laundry, right?
yes,
And how far is it from the house you and Aaron left from to the laundromat?
I don't know,
How long did it take you to get there?
like 10, 15 minutes.
And how long were you at the laundromat before the victim showed up?
A minute or two, I don't know exactly.
And then, fair to say, could you go back to the two? No, I'm sorry, go to exhibit 3. Yeah, please. Blow that up, please. Is there a timestamp? Is there a timestamp on that picture? Is there a timestamp on the next picture, exhibit 4? No timestamp. Can you show us exhibit 5? No timestamp on that. Is that correct? No, the witness.
What is it?
Well, let's try it this way. Is there any timestamp on exhibits 3, 4, 5, or 6?
No, there's not.
Would it be fair to say that the pictures that we're looking at in exhibits 3, 4, 5, and 6 were all taken literally within 3, 4, 5 seconds?
Yes.
Could you go back to exhibit 8, please? Could you pull that up as quick as we can get it? Are you telling this court that you can make out the faces of the two people that are in the front seat of that car? Yes or no, ma'am?
No.
Okay, but you told us earlier that you saw you and my client, right?
Yes.
Okay, could we go to exhibit 4? Floor up as big as you can. Are you telling me that you can identify with certainty the faces of the two people in the front seat of that car in that picture?
Yes.
You can. Okay. You can see the face of the driver? Yes?
Yes.
Okay. And you can clearly see the face of the passenger?
Yes.
And if you didn't purportedly already know what happened, you're saying you would be able to identify both the passenger and the driver in exhibit 4? Okay. Can we go to exhibit 5? Do you even see a face of the passenger in exhibit number 5?
Partially.
Partially? Is that as big as it gets? And you see a face in that video? In that picture?
Yes.
A face of who?
I'm sorry, a face of the passenger. Do you see a face of the passenger?
Yes, a reflection of my face, yes, off the windshield, yes.
You see your face in the windshield? Do you or don't? And okay, and exhibit, where are we at? 6? Put that up, please. Shrink it just a little bit. A little more. Little bit more. Just a skosh more. Sorry. Okay. Now you testified earlier that you when you got back to the house you were staying at, that you noticed damage to the front on the driver's side of the vehicle. Is that correct?
Yes.
All right. Is it in fact true, ma'am, that all of the damage you see in this picture is just above the wheel or just above the wheel well on the driver's side of the car? Right?
No.
No? You don't see that there's damage to?
Yes, I think there's damage there.
Okay. Do you see any damage to the front of the car?
Yes.
Where?
In front of the car.
Well, where?
In front of the car, I believe.
You see it with your eyes when you look at this picture, and we're talking about exhibit 6? Is this 6?
Yes.
I'm sorry, is this 6?
Yes.
And you're saying with your eyes, as you look at this picture now, blown up, you can see damage to the front of the car?
Judge, this is asked and answered. She said yes, she sees it by the light.
Okay. Now, what time did this meeting with What time did you go to, what time did you? Let me try to wait. What time was it when you say Jose got hit by the car?
Don't know the time scale.
What time do you remember it?
Don't know.
How long after you left the house was
I don't know.
it? You can't even estimate for it?
I don't know.
Did you not testify earlier that it took you about, you left sometime between 8 and 9 and it took you maybe 10 or 15 minutes to get there? Right?
Approximately.
Go to exhibit 2. All right, this is the video, exhibit 2 is the video of the event at issue, is that correct?
Yes.
Do you see a timestamp on the video of 13:33:25, which in regular time would be 1 p.m. 33 minutes and 25 seconds. Is that correct?
Yes.
And you heard the stipulation we put in that the timestamp on this video is 1 hour fast, or 1 hour ahead of what it should be. Is that correct?
I don't know that this witness would know that the time stamps were not ahead. Again, it's all out of personal knowledge.
You know what? You're right. Okay. But you will say that the timestamp does say 13:33 and 25 seconds, right?
In this picture, yes.
Okay. What did you do between the time you left the house at 8 to 9 a.m. and the time reflected in the timestamped video?
Had made a couple errands.
Well, didn't you previously say you went straight to the laundromat?
Yes. We did.
You did say that, right?
Yes.
And now you're saying
We
something.
went to London more than one time, yes.
And then, well, you knew the prosecutor was talking about the time that the event occurred, correct?
I don't know.
You didn't know that that's what she was talking about?
Wasn't sure the exact time.
I'm not asking you about the exact time. I'm asking you if you knew when she asked you about when you were at the laundromat, you were talking about and you were answering about at the time of the event, correct?
Yeah.
And did you not testify in direct exam that you got out, looked at, when you got back to the house, you got out, looked at the damage and the damage was on the left side, correct?
Yes.
You didn't say anything about there being any damage to the front of the vehicle, correct? In that initial answer you did?
It's on the front and side.
When you got arrested at the LA Insurance a little bit later, how long of time was it between the time the event at issue occurred and the time you got arrested up at LA Insurance?
I don't know.
You know how much time went by?
I don't know.
Can't you even estimate for us?
I don't know.
Did you do anything between the time you got back to the house after the event at issue and you went up to LA Insurance?
Just the house and LA Insurance.
And how far is LA Insurance from the house?
I don't know.
Can you estimate for us?
I don't know.
How long has you lived in that area?
Not long.
How long is not long?
I don't know the exact amount of time.
Estimate for us.
Maybe a couple months to a year, maybe.
Were you living with Aaron for about a year?
In Dearborn,
Okay, but you were living with him for about a year.
yes,
How long were you living with him at the house that you went back to after the event?
a year.
Okay. When you got arrested by the police, basically the first words out of your mouth were, "Hey, what's going on? Why are you arresting me?" Words to that effect, correct?
Yes,
Did you have any outstanding warrants for your arrest at that?
Judge, I object to the relevance.
It's fine. Rephrase.
Pardon
You can rephrase.
me? Thanks. Did you have, oh wait,
Because
did you know of any outstanding? No.
it has to be involved in theft, dishonesty, or falsehood.
No, I'm not using it to impeach you based on a prior conviction. I'm trying to figure out why they arrested you. Did you have any outstanding warrants?
I would object to the relevance.
Well, if she had outstanding warrants and she said, "I didn't know why they arrested me," that would be untrue. And it would go to her credibility. Were you aware of any outstanding warrants for your arrest at the time you got arrested during this event?
no,
Did you learn that there were any outstanding warrants for your arrest at the time you got arrested in this event?
Did not object to the relevance. She said at this time she didn't know, which would clear up Mr. Hart's issue of whether she lied to the police when she said, "Why are you arresting me?" If she later learned that wouldn't be relevant to the statement she made at the time she was arrested.
That's okay. Did the police tell you why they were arresting you?
they said the investigators would speak to me, and they said, I know why.
Did they put you in handcuffs?
Yes,
But they didn't tell you why they were arrested.
no, they said investigators would speak to me.
And you had no idea why they were arrested.
This is asking you. She said no.
When you gave two statements, right? To the police?
Yes,
Okay. One was on November 11th at around 3 in the afternoon, is that right?
yes.
Yeah.
I'm not sure the exact time.
Well, do you know how long it was after you got arrested? Did you talk to an investigator?
No, I don't know the exact time.
Were you taken to an interview room for that interview?
Yes.
Were you sitting in a jail cell prior to going to that interview room?
No, not when I first got arrested. I was sitting in headquarters at DDC. Headquarters, and then I went to DDC.
Were you interviewed at DDC?
No, I told them I did not want to speak to investigators.
When did you do that?
When did I do what?
When did you tell the investigators that you did not want to talk to them?
When I was at DDC.
When you were at DDC, did they read you your Miranda rights? You know what those are?
The police officers.
The police officers read you, when you say the police officers.
Yes, when they walked me over, yes, from headquarters to DDC, they did.
And is that when you told the officers you didn't want to talk about this?
I told them I didn't want to talk about this when they came to my cell at DDC every morning until they released me.
So prior to talking to the investigators, you had told the police you did not want to answer any questions with regard to this event. Is that a correct statement?
When I was at DDC, I did not want to talk about the investigation, correct?
Okay, but did you tell that to an officer?
Yes,
And where were you when you told that to the officer?
at DDC, behind the cell.
Okay, and how long before you were taken to the interview room did you tell the officer you didn't want to talk?
I was in the interview room before. Then I went to DDC and then they were asking me, do I want to talk to an investigator?
After you already talked to the investigators?
After I talked to the investigator, then they kept asking me if I wanted to talk to them, and I repeatedly said I do not want to speak to them until the hearing.
Okay, so let's back up. So had you already given your first statement to the police?
At the headquarters, before I went to DDC.
Before you went to DDC, and also before you gave your second statement, is that correct?
I gave my first and second statement at the same place at the same time before I went to DDC.
Where'd you give your second statement?
At headquarters.
Were you being housed at headquarters?
No. They rewrote the statement at the same place, same day, same time.
They rewrote it?
Yes, because I had lied to them the first time.
So they rewrote, they threw out the original statement?
Yes.
And then they rewrote it?
Yes.
You saw them throw it out?
Yes.
Just so I'm clear, you gave your first statement and then they threw that one out, correct?
Yes.
And then they rewrote it and had you sign it, correct?
Yes.
And that's the first statement you're talking about, right?
Yes.
Okay, and that was the day of the event, right?
Yes.
Okay, and then you gave a second statement on
The same day.
the same day?
Yes. They rewrote it the same day.
Okay, but my question is,
Sorry, go ahead, finish your question.
did you give a statement the day after you gave the first statement?
No, I gave the second statement right there at headquarters at the time.
How many statements did you sign?
One.
Between the first statement and the second statement, did you tell the police that you didn't want to talk to them?
No, I only told them that at DDC.
After you gave the second statement?
No, after I gave the first statement.
And then after you gave the first statement, they came back, and you told an officer that you didn't want to give any more statements.
Yes, at DDC, yes, the 72 hours I was there.
Okay, and that was after they had given you your Miranda rights, right?
Yes, yes.
Ma'am, are
I
you
don't know
under the
exactly.
influence of any narcotics or
No, I am
alcohol
not.
now?
You just keep asking the same question, but in a different way.
That statement that you signed, was everything in that statement the truth, according to you?
I don't know. Yes, it's my acknowledgement. The second statement was.
Okay, so the statement that you signed was an acknowledgement that you were at that time telling the truth.
In the second statement, yes.
Did they write out your first statement?
Yes.
That's the one they threw out?
Yes.
Oh. The house that you went back to after the event occurred. What street was that on?
Grandma,
Here. Does that house have a Ring doorbell or a porch video? That, from
Our
which you can
house.
see the driveway?
our house,
No?
no, our house didn't.
Did the police show you a picture or a video of you getting out of the
Yes.
Equinox?
Yes,
You know where they got that picture?
the neighbor.
How familiar are you with the area of the laundry? Where the event occurred?
I don't know exactly.
You
Enough to get around, to get there and back home.
How often do you go up?
I don't know.
Why do you go up? The records reflect a long pause before an answer.
I'm trying to object to the relevance of why on other occasions in the past, she's gone to the laundry.
Goes to her familiarity of the area and the people that frequent that area. So how often do you go up?
Normally, as any other person, I don't do that.
How many times in a week?
I don't know.
Estimate.
Couple, maybe. Normally, once.
You do your laundry twice a week, is that what you're telling me? You're also familiar with why other people go up to that laundromat, correct?
You're not objecting to lack of personal knowledge. I said why, if this person knows why other random individuals that she doesn't know may go to this area.
I'll try it a different way. At the time this event occurred, you knew that street people hung out at that laundromat frequently, right?
Don't know what you mean by street people.
How about prostitutes? You knew prostitutes hung out at that
I don't
laundromat,
see any
correct?
prostitutes at this laundromat in any of these
How about
exhibits.
drug users or drug sellers? You knew people went up there to buy
I
and or
don't
use
know what
drugs,
other
correct?
people do, but I'm sure.
But I'm sure, meaning I'm correcting what I said.
I'm not saying you're correcting what you said.
Well, didn't you tell
I'm
the police that
acknowledging
people
what
go
you
up?
said. Everybody goes up to the laundromat. I'm not sure what their reasoning may be.
Did you tell the police that drug users go up there to buy and sell drugs and to prosecute, sorry. The other kind, prostitutes frequently hang out in that area?
Everybody hang out in the area.
Okay.
Lawyers.
There's a lot of lawyers hanging out there?
Yeah, everybody goes to laundry.
I tell you.
Okay, so what about that?
Is there a washer and dryer at the home on Grandma?
Yeah,
And yet you choose to go up there to do your laundry?
yeah, because the dryer, almost caught on fire overnight.
One night way before this ever happened, right?
Yeah, actually, yeah.
Okay. Did you tell the police that streetwalkers hang out up at that laundromat? Yes or no, ma'am?
I don't know.
Was my client and you up there at the laundromat to make a drug sale?
Don't know.
Did you ever tell them that your client was up there to make a drug, my client was up there to do some kind of a drug sale?
No.
Why were you just sitting in the car, not doing anything for a while before anybody walked up to the car?
We saw somebody approaching the car.
Before that?
Yes.
How long were you parked before anybody approached the car?
I don't know.
Can you estimate for us?
No.
You don't remember at all?
No. I don't know.
I'm not asking you to check time. I'm asking you to estimate how long you were sitting there before somebody walked up to the car.
About a minute, 2 minutes.
Okay, what were you doing for that minute or two?
Sitting there.
Doing what?
I was sitting there.
Doing what?
Nothing. Watching the person walk to the car.
Okay. Have you used any drugs that day?
No.
Are you a regular drug user?
Well, I used to.
Were you a regular drug user at the time of this event? Did you tell the police that you can't believe you use drugs like that, or words to that effect?
No.
Okay. Why did you think you went up to the line? But when you got there, why didn't you get out and go into the laundry?
Because we see somebody walking to the car.
You're saying there wasn't enough time once you parked for you to have gotten out and just gone into the laundry. Is that what you're saying? Does my client do laundry with you?
Yeah, we have a show.
No. So the two of you went up there to do laundry, is that what you're saying?
Not at that exact time.
Well, at that time, at the time where the person got hit by a car, why did the two of you go up there
If
together?
somebody called us and told us, asked us to go out there, we don't know exactly why.
Well, why would you go? Why would you go?
Just said if somebody had called us and asked us to go up there.
To do what?
I'm not sure.
What do you think?
I don't know.
You had no
I
idea?
don't know. I don't know.
You had no idea?
I don't know.
Did the person call you or did the person call my client?
Your client.
Okay. So why did you go with them up to the line?
Because I'm always with Aaron.
Okay. So you didn't go up there to do laundry, even though you just told us you went up there to do laundry.
We were going up there to do laundry, but we still had a call to go up there.
Was there any laundry basket or clothes or anything, or soap or anything to suggest you were at that location to do laundry in the car that the,
I don't know.
you don't know?
No, I don't know. They had to.
What was your drug of choice back when this happened?
I would object to the relevance of that question, Judge. She said on this particular day, she was not under the influence, so what, on some other day, what her favorite drug is not relevant.
Well, okay, there were drugs in the car when the police got the car, right? Right?
I don't know.
And the police accused you of tossing or throwing something as they were driving into the area where the car was parked up at LA Insurance, right?
I'm objecting, Judge, I would object to the relevance of this witness having drugs at the time that the defendant is at the insurance company.
Well, if she was under the influence, she could say she didn't have drugs all she wants, but if there is circumstantial evidence that she either was or may have been, then that's relevant. You don't have to take her word for it. There were drugs in that car, weren't there? The one that you got arrested in up at LA, insurance? Right?
No, there was no drugs found on me.
And you have no idea why you went up there. Okay.
Yes.
Who supplied you with your drugs?
Judge, I object to the relevance, don't answer.
Did my client provide drugs to you? For you? Did he give you the drugs that you took back when you were taking drugs around the time of this event?
No.
Where'd you get your drugs?
Judge, I would object to the relevance, don't answer.
Did you know the victim in this case?
No.
Did you ever met him?
No.
Did you know his name?
Just as asked an answer, she said she didn't know.
Well, I cannot know somebody and still know their name or know who they are. I'm very familiar with Al Kaline, but I've never had the pleasure of actually meeting. Have you ever seen Mr. Tisdale and the man that got hit with the car together?
Not till that day.
Were you high or drunk enough before this event?
I object to the relevance.
No, I asked her if she was high or drunk then. Because there may be, just like you can still be drunk after you stop.
She already answered this, she wasn't. Okay.
Did the police ever drug or alcohol test you after they arrested you? No. How many cop cars came into the parking lot just before you got arrested?
No.
You have no idea.
Judge just asked an answer, she said she doesn't know how many cars.
There's a difference between saying, I don't know a specific number and being able to estimate. Was it more than one?
Yes.
Was it more than 5?
I don't know.
You have no idea how many cop cars came out there.
This was asked an answer.
That's an answer, it's the same.
Is that because you don't remember?
Cannot see how many cop cars are approaching me when I'm facing the LA.
How many cop cars were
I don't
there?
know.
Judge just asked an answer, she said she
Wait a
went
minute.
back to the parking lot, she doesn't know.
You were taken out of the car, right?
Yes.
And you were cuffed, right?
Yes.
And you were standing in front of the car that they had put Aaron in for several minutes, right?
Yes.
Okay, so you clearly had an opportunity to see how many cop cars and how many officers were out there, right?
No, the officer told me to face the camera and don't move.
Were you talking to Aaron at all or mouthing words to Aaron at all or signaling to Aaron at all while you were facing the car he was seated in?
Yeah, I told him I believed him.
Okay. Anything else?
No.
Did you get scared when you saw the cops rushing into the parking lot? Yes?
I didn't see the cop rushing in my, I didn't see them going into LA Insurance. and wasn't scared.
You're saying that nobody approached your car
I wasn't
simultaneously?
scared.
Excuse me, are you saying nobody approached your car simultaneous to the time they went in and arrested Aaron?
They approached Aaron, then they came to me.
And did you see them arresting him?
Yes.
And how did that make you?
I would object to the relevance of how she felt.
Because if she's panic stricken about what's going on, because allegedly she was a witness to what happened, it may have some influence on her credibility about what she's been telling the police.
That's where she was.
She was what?
She was.
I'm sorry? Look, I'll try to
rephrase.
Did you get scared when they when they arrested Aaron?
Yeah.
Did you get scared when they came to the car and took you out of the car and arrested you? Were you panicking?
No.
Can you think of any other words that would describe how you felt when you saw Aaron getting arrested, and then how you felt when they arrested you?
Judge, I would object to the relevance, and it's also a compliment.
Well, it is a compliment.
One question at a time.
Okay. Can you think of any other words to describe the way you felt when you saw police arresting you?
And I'll object to the relevance of that question.
It's one thing if she's just calmly. You can't think of any other word? But you have a four-year college.
Yes.
And yet you cannot come up with one other word other than scared.
Judge, I would object, this is argumentative.
You do have a college.
This is argumentative also. Her level of degree does not matter for how she's answering these questions.
Well, wait a minute. Her level of education goes to a lot of issues, one of which is her vocabulary.
She indicated that she was scared. I know it's scared.
Oh, okay, and I asked, was there any other words she could think of that would describe how she felt?
She said no. That's the answer.
Okay. Can you describe any other words you felt when they came to arrest you? Describe how you felt when they put you in handcuffs. You don't know?
No.
Okay. Did you make any movements or gestures in the car prior to getting arrested, shortly before getting arrested? What'd you do?
Judge, I would object to the relevance of what she did in the car.
It has to do with other police reports in the case and what they are alleging they saw her doing. The witness, yes. Did you do anything in the car? Did you move anything, throw anything, try and hide anything? And I know that's kind of complex. Put it all together. Shortly before you got arrested. You're not sure?
She said no.
No, she said no, as though she was about to say something else.
Judge, can we approach, please? Can you pass that way? Back to the hall?
Okay, so here's where we are. Then it's terribly important that you tell us the truth about every single thing. Okay? Because we have some real questions as to whether or not you've done that. The court is inclined to appoint you an attorney to impress upon you how important it is for you to tell the truth. Because consequences can be severe for you not telling the truth about everything. Regardless if it seems relevant or not, it's important that you tell us the truth about everything. You understand?
Yes.
Judge, on Thursday, I've got a 10 and a 10:30 Zoom and a 1:30 live exam. I'm not sure I can make it on Thursday. I could make it Monday, if that helps.
Monday at 1:30.
Thank you.
Is that work for the witness to be back Monday at 1:30?
Yes.
Works good, people.
Okay. But I have to leave me some contact information because the attorney that I will point to is going to get contact and talk to. Just don't want you to get yourself in trouble. Okay? So make sure that you're protected. Got it? All right, so get the information to the prosecuting attorney so I can let you talk to. Thank you. What's that? Okay, so this matter is held in part and will be continued December 11th at 1:30.
You didn't pass him any paperwork, did you, counsel? You didn't pass him any paperwork, did you?
No.
Okay.
Oh, wait a minute. Yeah, he had like 3 sheets of legal papers. I don't know what he.
Oh, okay. No, I just want to make sure you didn't give me the documents with statement.
No.
Yes, okay, so. Yes.
And it's just keep on coming.
Oh, yeah, yeah.
And some kind of pictures. Yeah, because I don't, you know, I can see it. I can see where, you know, it was.
Okay.
It doesn't, but I don't have the equipment. Yes.
Thank you, Judge. Nice to see you as always.
Do you want to copy the perspective order?
Sure.
Or you can leave it with recorded. I said I can leave it with recorded. Oh.
Oh, yes.
Have a good day, everybody.
Thank you, you too.
Thank you.
That concludes the docket for today, folks. So we'll see you tomorrow, same batch, same batch.
They called up again for paperwork on that witness. I don't have anything. What witness? The one that was downstairs. Yeah.
We're gonna make us a snack joint here, young. We making a snack joint.
Judge, did you know Corey that was a court reporter? Corey, he's a guy that was a court reporter.
Another guy was in here. Wow.
Yeah, it's a.
He passed away.
Corey, what name, Corey?
Him and his brother, yeah.
I don't think he ever worked with me. I think the only male court reporter I ever had was Robar and Richardson.
So did he put some of your desktop?
JVS.